All right, we'll come to order, and we'll ask our secretary to call the roll.
Chairperson Barney,
Yes?
Vice Chairperson Llewellyn.
Yes.
All right, the commission is in session, and we're ready to resume the hearing. Before we pick up where we left off yesterday, there was a motion filed yesterday evening, I believe. Is it the respondent's motion or your motion?
It was our motion. The
Appointing authority's motion. All right, so you can proceed on your motion. We'll hear, what's your motion?
I think it might make more sense to take that up, you know, at the end of the day, because it's about scheduling for, you know.
Oh, all right. Well, is that all right with the commission members?
That's fine. I do want
And we're gonna have a hard stop at 4, so we may make sure we get it
Okay.
before us before 4 o'clock.
Right.
Okay. Okay.
All right. So with that, then, the witness come back, take her seat on the witness stand. The witness has already been sworn yesterday and is still under oath. And where we left off yesterday, the appointing authority had used 9 minutes of the 35 minutes for direct, so he has 26 minutes left. 26 minutes left this morning, if my math is right. 26 plus 9 is 35, right? So 26 minutes left. It's clock I have here, it's 10 minutes, 10:02, so 26 minutes would take us to 10:28. All right, so you may proceed.
All right. Good morning, Ms. Baker.
Good morning.
I think where we left off yesterday, you had talked about the fact that you and Jared Boyd had the meeting with the director. Is that right?
Correct.
Okay, and then based on what you learned from that meeting, as well as from the meeting that you had with Mr. Unestall and Ms. Lambert, there were some additional things that you all decided you needed to do, correct?
Correct.
And one of those was to talk to Dr. Bird.
Yes.
Okay. And was there a need to speak with Dr. Bird to kind of further look into what you had learned?
Yes. Since he was the person who had accompanied Director Gray on this trip, we felt he was relevant to speak to about this incident.
And what he would tell you, I take it, would help determine what if any action you would take.
Correct.
Okay. And so, did you then have the meeting with Dr. Bird after you met with the director?
Correct.
And in that meeting, what if anything did Dr. Bird tell you?
He confirmed that he had taken the trip to Jefferson City with Director Gray. He confirmed that she had asked for the black car with tinted windows and no city markings to take him on this trip. He talked about the encounter that they had had in Jefferson City with Reverend Gray. He talked about returning to St. Louis with Director Gray and going to, he wasn't sure on the order, but something around the lines of to her home, to her daughter's home, and to a casino. He talked about concerns with what they were picking up for the home, even mentioning perhaps that they were looking for weapons when they went to the home. And so that is what he told us.
Okay. All right. And based on after these meetings and what you had learned, did you ask for statements from the people that you had spoken with?
Yes, we asked for written statements from Bianca Lambert, from John Understall, from Anthony Bird, and from Director Gray.
Okay. And then, is that our?
I don't think so.
We're handing you a stack of exhibits. Just take a look at Exhibit 2.
Okay.
And what's Exhibit 2?
Exhibit 2 is the letter from Director Gray summarizing her meeting with us and the events of July 3rd.
Okay, all right. Did you, so after getting the you know, again, just talking about the next steps in what you all did to sort of look into this matter, did you meet with the director again?
We did meet with the director again. In that time, Jared had also procured the car log, so we knew that the trip had occurred using a city vehicle, confirmed. We also knew from this letter and from her personal statements to us when we met with her in the office the first time that she was affirming that this did happen, that it was for a personal matter. So yes, we met with her after that to talk about discipline.
Okay, and in that second meeting, was that again just you, Mr. Boyd, and the director?
Correct.
Okay. And if you can recall, when did that take place, the second meeting?
I believe the second meeting was on Thursday of that week.
Okay. Which would have been like August the 22nd?
Yes.
Okay. And then, so in that meeting, what do you tell the director?
It was fairly brief, honestly. We told the director that we had gone through the statements from Jana Understall, from Bianca, and from the director herself, and we had reviewed what we had from Anthony, and we were going to move forward with termination.
Okay. And did that mean, with the pre-termination process?
Well, this position is unique, which is why we're all here today. So we told her that we would be providing a pre-termination notice, which we would give to her the following morning on Friday.
So take a look at Exhibit 1.
Okay.
And is that a copy of the pre-termination notice?
Yes, this is.
Okay. And that's something that was provided to the director, is that right?
It was provided to the director. She knew that it was coming. It was provided both via email and certified mail.
Okay. I want to ask you, were you present for some of Director Gray's testimony?
Yes, I think the first day.
Okay.
I don't know if it went a second day.
Do you recall testimony regarding keeping former Director Franks off the reemployment list?
Yes, I do.
Okay. Can you tell us, what do you? First off, let me ask you this: is that true? Were you attempting to keep Richard Frank, the former director, off the reemployment list?
No, we weren't trying to keep him off a reemployment list. The situation with Rick Frank was very confusing because we didn't actually know, when the letter that he had sent was from. We didn't know for sure what letter we were talking about. But we did know that per Civil Service Rule 7, the director shall put him on a reemployment list. So we were inquiring about where that process was.
Okay. And as far as you knew, so you inquired with the current director about this whole reemployment?
Right, because we wanted to understand what the status was of that particular endeavor, and we also were willing to provide suggestions on other places if the director of personnel position was not open or eligible for a reemployment list.
Okay. Did you know at the time whether or not the current director had placed him on the list?
It's very hard to know. We had heard kind of conflicting things about this. We had heard that there was a letter. We did not know for sure if he was on a list or not on a list. This also, as Bianca testified yesterday, was a second letter. So we were really trying to track down the pathway that this letter had gone on.
And so, do you even know when Director Gray actually received the reemployment letter?
I don't know exactly when she received it, but I think it was in the fall of 23.
Okay. All right. And so I take it you weren't applying any political influence or interference in regards to this reemployment letter?
We were trying to resolve an issue that needs to be resolved per Civil Service Rule 7. We weren't applying political pressure to Director Gray.
Okay. All right. Give me 1 second. That's all I have.
Cross-examination.
Good morning, Ms. Baker.
Good morning.
Now, you have been tasked along with Mr. Boyd to conduct this investigation as it relates to my client, correct?
Correct.
And were you delegated any responsibility in that regard?
Can you clarify your question? I was working.
You have a written delegation of authority from the mayor to allow you to conduct the investigation.
No, but as you well know, Jared Boyd does, and I work as his deputy.
Okay,
So
when-
all I did, sir, was follow up with emails asking people for written confirmation of the statements that they had given us.
Okay, well, you actually interviewed folks, didn't you?
Yes, because Bianca and John came to me originally.
Okay, so you did more than what you just described. You actually conducted interviews, correct?
I was present for interviews, and I asked for follow-up information from those interviews.
Well, in the first interview that was conducted, Mr. Boyd wasn't even there, right?
We didn't know what incident we were talking about at all at that first interview. We had no information. And I would note that we had no information even though the instance had occurred on July 3rd and we're now talking about August 19th. We had no information
So
about what
is
that
a
complaint
yes
was
to
going
my
to be about.
question. Could you answer my question? He wasn't there. Mr. Boyd wasn't there. Can you
No,
agree with
because
that?
that was
I didn't ask you just a yes or no question. He wasn't there.
Jared Boyd was not there for the
Thank you.
conversation with
Okay,
Bianca
that's-
Lambert and
that's
John
all I need from
Understall.
you because I have a limited amount of time. So
Sure.
let me conduct my examination and then council can elicit whatever. Okay. So you didn't have a delegation of authority. You were in a meeting without Mr. Boyd, and this delegation of authority that he received was signed on the same day as the letter of termination. You're aware of that, aren't you?
As you well know, there is another letter of delegation that happened at the beginning of the administration.
Okay. With respect to your investigation, along with Mr. Boyd, and let's talk a little bit about that. You talked about the fact that as it related to Mr. Rick Frank, you were making inquiries regarding his status, right?
Correct?
Why?
Because we needed to know what was going to come next.
Why?
We needed to know if the director had done her job.
Why? What
It's
about
not
her
relevant
job,
to
what she had
know.
done? You were inquiring about Mr. Frank because, as you indicated, you were trying to figure out if you could send him out to the airport somewhere instead of having him reappear as the director of personnel. Isn't that right? We're under oath here. Isn't that correct?
We object to the relevance of.
Per Civil Service Rule 7, the director shall put him on a list. She had not done that, having received the letter much earlier in her tenure.
How do you know she hadn't put him on the list?
That is what we were aiming to find out, because
Well, why
we
were
had
you
complete
asking about that
ambiguity.
in the first instance? Who told you he wasn't on the list?
We had heard rumors that there was a reemployment list.
Rumors. Okay. You heard
And she
rumors.
confirmed, sorry, may I further answer your question?
No. Answer my question, and then you can say whatever you want to say in response to him. You don't know whether or not he was on a reemployment list or not at the time, do you?
That's why we had to ask a question, sir.
You didn't know at the time, correct?
That is why we had to ask a question.
And you were asking about whether or not he could go to some other place. Why were you asking about that? Why did you care about whether or not he went out to the airport?
We were asking about if she had put him on a list, as is required under the civil service rules.
Okay.
And we were open to providing suggestions. But it is ultimately her duty to decide what list he ends up on. She
It's
had not
her
do that.
duty, right? Why are you imposing yourself on her obligations?
It is very clear that she needs to do that. She had not done that. She had had that letter for a long time.
Why were you interfering in personnel matters when you just acknowledged that it's her duty?
We were not interfering with personnel matters, sir.
How many investigations have you conducted?
In my current role,
Yes,
when instances, I would say 3.
3 investigations, okay. And then you were involved in this investigation involving my client, right? In conducting that investigation, did you have any discussions with the mayor?
We only kept the mayor.
You, I'm not talking about
No.
we, I'm talking about you. Did you
Then
have any discussions
I will
with the mayor?
specifically answer your question, sir. No.
Okay, that's all I want to know. What role did the city council play in this investigation?
We informed the city
But
council.
not we. I'm asking what you did.
Then my response to that is going to be I didn't have a lot of direct conversations with Sheena Hamilton.
Well, I believe you testified yesterday that when Bianca came to you, you called Jared and then you called the city councilor, right?
Those are your words. I informed Jared. Jared called the city councilor.
Okay, so when you said we called the city, you meant Jared called the city council.
Correct.
You know why he called the city councilor?
To get advice on this unprecedented instance that we were dealing with.
Okay. So you reached out to the city council to get advice to enable you all to move forward with your investigation, correct?
To understand the process.
So you could facilitate the investigation.
Yes, we needed to figure out how to
Okay,
proceed.
Okay, I mean, this is easy. I'm giving you softballs right now. Now, in conjunction with this investigation, did you determine any inconsistencies between the information you were receiving from the various witnesses?
Well, we never got the text messages from Anthony Byrd, so it was difficult to know what was in those text messages. When we talked to Director Gray, she refuted some of what Anthony had told us. She refuted some of what Anthony subsequently said, because we interviewed him later in the day. But not the substance of what had occurred, just the circumstances around why they took the trip.
Well, Bianca had told you he was a notorious liar, right?
She hadn't provided her statement to me at the time that I talked to Director Gray.
Okay, when did you get that statement?
I don't have it in front of me.
Would it have been before you issued the charges?
Yes.
Okay, so you knew before you issued the charges that Anthony, according to Bianca, was a notorious liar, right?
We knew that that is what she alleged.
Right, okay. And did you factor that into your weighing and balancing what to do? The fact that you have one of your witnesses, the whistleblower, saying we've got a notorious liar here?
Absolutely, we thought about that. That is why it was very important when Director Gray herself confirmed what had happened.
Okay, fair enough. Let me direct your attention to the appointing authority exhibit 13. What is that document?
I think I'm on 12. Sorry, did you say 13?
13, yeah.
So I'm on tab 13, but it says exhibit 12. I should do the next one? Wrong binder?
It's in the, do you have a copy of your binder, exhibit binder? Okay, why don't we scan or copy that? No, it's just,
Is it this one or this one?
It's this one, I
Oh,
thought.
okay. Sorry.
now is this the motor pool experience record log that you all obtained as part of your investigation?
Yeah, this is the municipal garage log.
And did you review that document?
I did review this document.
Okay, and did Mr. Boyd review that document?
Yes,
Okay, and you reviewed that document in order to identify whether or not there's support for this round trip to Jeff City, right?
correct.
How many miles
The
round
total,
trip to Jeff City?
I don't have that number off my head.
Okay, does 220 sound about right?
About right,
All
yeah.
right, how many miles are reflected on this log?
767.
It started at 767, it
Oh, sorry,
ended
it's
at
roughly-
1488, right?
Yep,
So there's an extra what? I'm not a math wizard, but that's an extra 488 miles, give or take, correct?
correct.
Did you inquire of Mr. Boyd regarding what happened and what city business he was doing between the time he checked it out on
7-3.
7/3 and 7/10 with respect to the 488 extra miles?
We are not Dr. Anthony Boyd's appointing authority.
No, that's not my question.
So we did not
That's
have a
my
conversation
question.
with.
Answer my question.
Could you
Did you
restate your
inquire
question?
of him as part of your investigation where the 488 miles came from over the holiday weekend?
We did not have this car log when we spoke to Anthony Byrd.
Okay. At any point when you got this, did you inquire about the extra 488 miles?
I did not.
Why not?
Again, I am not Anthony Byrd's appointing authority, so I have
Okay,
no
so you
ability
can
to
see a
discipline.
violation of 488 miles. You didn't even inquire on whether or not he was driving around the city block to run up those 488 miles, right?
I did not inquire of Anthony Byrd.
You didn't care, right?
Those are your words, not mine.
Those are your words. You're saying that's not my area. I'm an investigator, but I can ignore 488 miles that are in violation, let me finish, counsel, that are in violation of the city vehicle policy. You can ignore that.
It's asked and answered, so the objection sustained is asked and answered. She's already said she did not.
Do you have an obligation to report misconduct that comes your way as it relates to your position as deputy chief of staff?
In the span of this investigation, We were not investigating
That's
Dr.
not my
Byrd.
question, ma'am. I moved to strike it. My question is, do you have a duty and obligation to report misconduct that comes your way like you did when Bianca came your way?
Yes, I'll report
Okay,
misconduct.
all
when it
right,
comes my
so
way.
if you see 488 miles, it may not be in your bailiwick, but you have an obligation to report that to somebody, don't you?
This was already in the comptroller's office. They have this car log. It was part of our investigation. I did not further report Anthony Byrd as he's not under my jurisdiction, but this has been known to the comptroller's office. It's known to our office.
Okay, so your focus
Ultimately,
was
the
simply,
discipline authority resides with Director Gray.
your focus was simply on the director, and you didn't care if Anthony Byrd was driving around the block for 488 miles personally with a city vehicle. You didn't care about that.
Again, sir, I
Objection,
never
asked and
said.
answered.
Sustained.
Okay. You know if Mr. Boyd inquired about the extra 488 miles that would have been in violation of the city vehicle policy?
I do not.
Do you know why he wouldn't have?
I said I do not know. I don't know if he inquired as to that.
And you don't know why he wouldn't have, right?
I'm not going to speculate on what was going through
Okay.
Jared's mind. I'm
And he
just-
would have had the same obligation as you had if you found and stumbled into what might be a violation of the city vehicle policy to do something or say something, right?
Misconduct is misconduct. We report it when we see it.
And did you report it?
We did not further report Dr. Anthony Byrd. However, this log lives in the comptroller's office, which is charged with investigating fraud.
And she's got dozens of logs in there. She's supposed to flip through logs to try to find inconsistencies. Is that your testimony here today?
No, I'm not testifying about the comptroller's role. I'm simply saying that she already had this information.
Along with dozens and dozens of other logs, right?
I'm not aware of the full comptroller's workload. I do not work in that office.
Fair enough. And then in destination, you see that under destination? What does that destination say?
City.
City, right? Doesn't say Jefferson City, right? It says city, right?
Yes.
So he lied when he had somebody write city on this official city log, right?
I don't know exactly how you're supposed to fill this one out, but I assume, I don't know if it's like I returned it to the city and that's what he's saying, but
Well, it says destination. You
Yeah.
can read, can't you? It says destination, right?
yes, sir, I can read.
And the destination, it says city, right?
It does.
And you knew from interviewing him that he knew in advance that he was going to Jefferson City, right?
He returned the car to the city of St. Louis, so I didn't focus much on that
You
destination.
didn't care about that,
You
right?
were the one, sir, who said I don't care. I do
Well,
care.
it has Osage Beach on there, right? So somebody was going to Osage Beach, right? Right? According to this law.
According to the log, yes.
But according to the log, Mr. Anthony Boyd spent,
I think it's Byrd.
I'm sorry, Mr. Byrd, Dr. Byrd, I'm sorry, Dr. Byrd denominated as city, right?
He did, yep.
And that didn't trouble you at all.
Objection, asked and answered.
Sustained.
I'll withdraw it. You didn't report the fact that there was a problem with this destination entry by Dr. Byrd, right?
Objection, asked and answered.
Sustained.
I didn't ask.
She's already said she did not report anything with regard to Dr. Byrd.
No. I asked her specifically about the city designation. Before we were talking about the mileage designation. Now we're talking about a totally different question.
It's 10:24.
I understand.
Started at 10:10.
I understand all of that. You didn't report it, and you don't know if Mr. Boyd reported it, correct?
I did not report the city destination. This this log lives in the comptroller's office, which is the appropriate place.
The witness will answer the question and not.
Okay, I did not report.
Just answer the question.
Fair enough. July 3rd was a short workday, wasn't it?
No,
It wasn't?
no, it was not.
Okay. What time did the director start working that day?
I do not know.
You don't have a clue, right? Right?
I do not know.
Do you know if she starts working at 4, 5 in the morning on city business?
I do not know what time she starts
Do you
working.
know if she works into the wee hours of the morning on city business?
What I know related to this question, sir, is that sometimes I receive emails from her at different times, but
At after hours,
Sure.
before hours?
yeah,
Which suggests she's working, right?
yes,
You talked about common sense yesterday. Common sense will tell you if she's sending an email at 5 in the morning, that means she's working, right?
right.
And if she sends it after hours, she's working, right?
Right.
She's not a 9 to 5 person. We can agree to that, can't we?
Correct.
All right. So, in your investigative summary, let's take a look at that, which is exhibit, well, it's in our binder as exhibit 28. Take a look at that.
So I only have 20 tabs. Is there a way?
Let me look at it, 'cause my clock is ticking.
I go to 20?
Oh,
20?
that's there.
Staff,
Yeah, that's there.
the two other binders for the commissioners, yesterday we had them.
Okay, so this is yours.
Yes.
Got it. Okay.
All right. Take a look at that. Who prepared that investigative summary?
These were my notes from the interview.
These are your notes, right?
Correct.
And what time did Mr. Bird say, well, let me help you out since we're pressed for time. According to the interview he gave you, he finished up at 9 p.m., correct?
Correct.
Right? So he told you during this interview that whatever transpired that day, the last drop was 9 p.m., correct?
Yes, that's what he told us.
Okay. Now, beyond this investigation involving this incident, did you conduct more investigations into other activity?
Related to the director?
Related to the director. That's why we here.
I inquired about some of the credit card charges that she had had.
And what'd you find out?
Kind of inconclusive on the credit card charges. I talked to the comptroller's office about those expenditures. And, they advised that they had sent the credit card policy to Director Gray, that some of the charges didn't align with that policy. We didn't move a lot further on the credit card policy.
Because there was nothing there, right?
It wasn't that there was nothing there. It was that the director had been informed of the policy. Some of the charges, it sounded like, had already been taken care of. It wasn't the nexus of this investigation.
Time check. How much time is it?
It's 10:28, so you, you have, you got till 10:45. So you got 17
Plenty of time.
minutes.
All right. Let's look at Exhibit 1. I believe it's Exhibit 1, which is the notice of termination. Yeah, pre-termination notice. Do you have that in front of you?
Are we back in the other binder?
You're back in the other binder. I'm sorry.
Okay. Yeah, I don't have anything on that one.
Yeah.
Yes.
All right. Who prepared this letter?
This was prepared by Jared Boyd.
Okay, and do you know if he had any discussions with the mayor regarding this letter before he prepared it?
I do not know if he discussed the content of the letter with the mayor.
Did you and he collectively have meetings with the mayor to discuss this issue concerning the director?
We kept her apprised of what was happening, that this allegation had come forward, but I didn't talk directly to the mayor to update her on this case.
Okay, when you say we talked to her, you mean
Jared,
Mr.
yeah,
Boyd?
you'll have to talk to him about his conversations with her.
Okay.
I didn't.
You weren't privy to those, is what you're testifying to today.
I didn't have conversations with the mayor about a pre-termination letter. I had conversations with the mayor along the lines of, this is happening, that we're doing this investigation.
Who made the decision to send the letter?
The decision to send the letter came through Jared Boyd as part of his delegated authority.
Do you know if the mayor approved this letter going out?
You would have to ask Jared about his
I would have
conversations
to
with the
ask
mayor.
Jared. Okay. And in the letter, it says that a pre-termination review and public hearing has been scheduled for you on September 3rd, 2024 at 10 a.m., correct?
Yes.
All right, and that's a lie, right?
I wasn't involved in the scheduling, so I can't really speak to that. We didn't have a pre-termination hearing on September 3rd, 2024.
Well, we didn't have one scheduled on September 3rd.
I wasn't involved with scheduling, so
Who was involved with the scheduling?
I think that was through Jared trying to coordinate the commissioners' schedules.
That was Jared, and so we'd have to talk to him about where this date came from, correct?
Correct.
All right. And there's references to the fact that this is a pre-termination notice, but in fact, you all in discussion realized that that really didn't apply to this situation, did it?
Well, we had notified Director Gray that we would be giving her pre-termination notice that Friday. So that is what this letter is.
Okay. Have you had any discussions, or conversations with anybody on the commission?
No.
All right. Do you know if Mr. Boyd had any discussions, conversations with
I know
anybody?
he's had scheduling conversations to try to find a date.
How do you know he had scheduling conversations?
He talked to me about that, trying to find a date.
Okay, how many scheduling conversations did he have?
I don't know.
Does the number 22 scheduling conversations, did that ring a bell at all?
No. I don't know how many conversations he had.
Okay, do you know of any reason why Mr. Boyd would have 22 conversations with the chair of the commission?
I think we've seen here scheduling's been a bit difficult.
Okay, so 9-minute calls, you think there were some discussions for 9 minutes about scheduling, is that?
I wasn't on those calls, sir.
So you
I
don't
can't-
know?
Right. I don't know.
Fair enough. All right, now,
And just to be clear, Mr. Norwood, in your question, your reference was that to the chair at that time, I would say.
at that time, meaning Chair Dean Dybel, you don't know anything about those discussions?
I never spoke to that commissioner.
Okay, fair enough. Now, when you all decided to send this letter, did you take into account the exceptional performance of Director Sonia Jenkins Gray?
This letter was related to her malfeasance.
Right.
We, of course, are cognizant of her performance, but this was about the results of an investigation into malfeasance.
Okay, so you understood the fact that she was performing exceptionally in the position, right?
I would not say that Director Gray was performing exceptionally in the position.
But she was performing well in the position, and that's what the mayor has communicated to the public, correct?
I don't know what statement you're referencing from the
Okay, well,
mayor.
let's play that statement. Let's key up this statement from the mayor at the Charter Commission meeting. It's about a 3-minute statement.
Let me object. It's irrelevant. It's going to be hearsay.
It's a comment by this witness on another, the objection sustained.
She said she wasn't aware, were you at that Charter Commission
I'm just
meeting?
saying I don't know what specific
Right.
comment you're talking about.
And that's the comment I want to play, to refresh your recollection.
Well, all right.
It's still irrelevant.
It's
What's
highly relevant.
is, I believe, the question was, were you aware of her exceptional performance? The answer was, we were cognizant of her performance. I would not say that she was performing exceptionally. Then there was another question, I'm sorry I didn't get.
The next question was, are you aware of the fact that the mayor has publicly commented about the great work that Director Sonia Jenkins Gray is doing?
All right, I think there was another one in between, but at any rate, are you aware? And her answer was no, she wasn't aware of the specifics. So.
She wasn't aware of the
The
specific
issue
statement.
is, did she take account of the performance?
Yes.
All right.
She said, and the witness said.
No, so the objection is sustained to playing, at this point in time, a recording of what the mayor said,
Fair enough.
unless,
Were you at that Charter Commission meeting when the mayor spoke?
I don't even know which one you're referencing. There were many charter commission
Okay.
meetings. I listened to some of them online. I was not physically present.
Okay, how about the one that transpired on the 10th of January of 2024?
Sir, there were many charter commission hearings. I don't remember that specific one. I might have watched it virtually,
Okay,
but I
if we
wasn't
showed you a
present.
clip, would you know whether or not that was the meeting you were in attendance?
I would probably remember if I saw it or not, but I
Okay.
wasn't physically
Well, can
there.
we play the clip to refresh your recollection as to whether or not she was in that particular meeting?
What does this even go to?
It goes to the heart of what we're saying, which is the fact that your client in an effort to conduct a hostile takeover of civil service, made publicly known that she wanted to sweep the Department of Personnel within the control of the mayor's office.
And so
That's
you-
how it's relevant.
So you think this witness is gonna testify to that inflammatory statement?
Well, we don't know what she's gonna testify to until she refreshes her recollection about the statement.
The question was about the director's performance. This witness, based on her personal knowledge, said she didn't know that she would say it's exceptional.
That
and
ship
so that's
sailed,
it.
that ship sailed.
Now, that isn't it. She hasn't been asked what was her understanding of the
What I'm
director's
trying
performance.
what I'm trying to do, Your Honor, is refresh her recollection about whether or not she was in this particular meeting, and she just said, in order to figure that out, she needs to see the clip.
Right, you're on oranges, he's on apples. The objection is sustained to playing the tape of the mayor's statement at the Charter Commission. That is irrelevant.
It is irrelevant
At this point in
if,
time.
if
to any
this
question of
this person is a
It's
witness,
irrelevant to your questions of this witness.
if this witness witnessed her boss come out in favor of a hostile takeover of the Civil Service Commission, it's highly relevant. She is a witness.
I understand that Ms. Baker's a witness, Mr. Norwood. All right?
And that's all I'm trying to establish is the fact that she was there or she observed her boss.
She's just testified that she wasn't there, that she
No, she
saw
said she
some of
didn't-
them online.
Right, she wasn't there. It was a Zoom session, right?
Most of them were on Zoom.
Right, and you would have watched it on Zoom, and so this particular one where we would like to play would refresh your recollection as to whether or not she made these statements in that session,
And
correct?
what is the relevance of, assuming it refreshes her recollection of what the mayor said, how is her memory as to what the mayor said relevant?
Because she, Mr. Boyd, and the mayor are fully aware of the various efforts to interfere with the Director of Personnel and Operations, to take over the Department of Personnel to the detriment of 5,000 city employees. That's the heart of our defense.
All right, it may be the heart of your defense. However, it is irrelevant to this witness.
Fair enough. I'd like to make an offer of proof at a convenient time to play the clip to confirm whether or not she was at that meeting. Is that acceptable?
And we will have to do that. I think, I hate to say it, but I think the most practical way is simply to do it now.
Okay, so
It has
let's,
to be on the record, as I understand the
yes,
rules.
yes, so let's
So,
play the clip as an offer of proof.
This
And
is,
why even
this,
sustain the objection if we're gonna?
yeah, it's an offer of proof, Mr. Harris. Your objection has been sustained.
Yeah,
Right.
but it's effectively overruled, so.
No, it is not effectively overruled. An offer of proof is something that is not admitted into evidence,
Okay.
all right? It is the nature of the fact that the city charter says that this is a public hearing, that all of this, whether it's admitted or not, and something a witness says or a question that's stricken from the record is still aired at a public hearing, all right? So the tape at this point has been ruled inadmissible. Your objection to relevance as to this witness is sustained. The admission of evidence stops at this point. The offer of proof then is put on by the respondent. After the offer of proof, we revisit your objection, and it's either then sustained and the offer of proof is not admitted into evidence, or if it's overruled, then that would mean Mr. Norwood could ask further questions about it. Now, it's 10, we've talked about this.
Yeah, it's a short offer
well,
of
I'm
proof
gonna-
and a short
you know,
video.
We're not gonna count all this time that we've spent on this as going towards your minutes.
Appreciate that.
I believe, however, I believe you'll only have 10 minutes left.
Yes.
Once we come back.
And this
All
is a
right.
short one.
Offer of proof, play the tape.
Both appointment and dismissal authority. For example, the fire chief, the police chief, airport director, and the director of personnel Side note, I believe that the director of personnel should be changed to the current nomenclature that's used by personnel, which is human resources or talent management, whichever we see fit. The police department and fire chiefs are currently hired and dismissed by the director of public safety. The city ordinance provides that the airport director is hired by the mayor, but the charter doesn't even mention the airport director, and the director of personnel is currently hired or dismissed by the Civil Service Commission. This all reflects an antiquated view of both public safety and civil service that's not accountable to the people. The hard-fought victories to make both public safety and personnel practices more responsive to the public should be codified in the charter by providing the person holding the office of mayor the means to ensure public safety and personnel leadership uphold those values. There is no reason to hold these positions separate in terms of accountability from other city departmental and administrative positions. One example, in the Department of Personnel.
Okay, were you at that meeting?
No.
Okay, fair enough. But you were aware of the fact that she did come out publicly to say that, in her view, the Department of Personnel should be under the umbrella of the mayor's office. You were aware of that, weren't
Yes.
you? Right?
Yes.
And she wasn't quiet about it. She was pretty vocal about that, correct? The
Yes.
mayor.
Yeah.
Okay.
All right, your offer of proof is over, right?
Yes,
In other words, simply to play the tape.
yes.
All right, the objection remains sustained.
And
Now,
the offer
I'm
of
not quite
proof
sure
is
whether
an
you
offer.
intended your question about was she aware that the mayor had made those statements?
Well, let me ask that on the record
All right,
as a separate and apart from the offer of proof, which has been accepted but denied as admission and evidence. You were fully aware of the fact that the mayor publicly commented about sweeping the Department of Personnel and the Director of Personnel under the umbrella of the mayor's office, right?
I was aware that she made statements about having those be direct appointments
Be direct appointments from her,
from the mayor's office.
which
yes.
gives her control.
Yes.
Okay, fair enough. Now, as part of your investigation, do you know whether or not Director Jenkins Gray ever received a copy of the vehicle use policy?
I do not know.
You don't know, right? And in the notice, what you say is that it's available online, right?
Correct. It is.
So it was incumbent on her and any other employee to swim through these various policies online to try to figure out what policy might apply to a situation, correct?
It's incumbent on the director to know policy.
All of the policies.
I would think if you're asking yourself, can I take a city vehicle somewhere, you might want to try to look up that policy.
Do you, well, let me ask you this. Do you know if the mayor relies on her staff to provide her guidance when she was new to the job?
Yes, the mayor relies on her staff for guidance.
And that's natural. That's normal for somebody new to city government to try to figure out how to navigate city government. There's nothing unnatural about that, is it?
It's not unnatural to ask
Okay,
questions.
fair enough. Now, are you aware of anyone being disciplined at any level for violation of the vehicle use policy?
I am not, but I wouldn't necessarily be involved in those discussions.
Okay, all right. So as you sit here today under oath, you don't know of any situation where anybody's even been disciplined.
I personally do not know, but it's not generally under my
I
purview to
understand
know.
that, but as part of your investigation, did you reach out? Did you call the comptroller's office to find out if she's aware of anybody being disciplined for violation of vehicle use policy?
I did not do that.
Why not?
I did not do that. I didn't have a reason for not doing that. I just did not do that.
Wouldn't it be important to know if you were going to, anybody, the mayor, Mr. Boyd, are going to go into the charter and remove the director of personnel for a policy violation? Wouldn't it be good to know whether or not nobody in the history of the policy has been disciplined? Wouldn't that be important to know? Isn't that common sense? You talked about common sense yesterday.
We were focused on the facts of her case.
You were focused on the fact of her case, and you decided to make a recommendation for termination without knowing whether or not this policy has ever resulted in even a letter of reprimand, correct?
I did not ask that question.
Okay, fair enough. Time check,
I have 5 minutes.
thank you. And along the same lines, you don't know if anybody's been terminated for violation of the vehicle use policy, correct?
I did not ask that question.
You did not ask that question. You know if Mr. Boyd asked that question.
I do not.
Let's go back to your summary.
Which number are we on?
That's Respondents Exhibit 28. That's your investigative summary and the big binder. Sorry. All right, now in that interview you had with Bianca, she acknowledged that she lied to you regarding her reasons for wanting to quit, right?
She told me that she had said they were because of stress, but she had not brought up the other issues related to the July 3rd incident. So she told me a half-truth.
When a half-truth, okay, so are we dealing with half-truths? Is that what you base your investigation on, half-truths?
No.
Objection argumentative.
I'll withdraw the question. She lied.
I do believe that Bianca is under substantial stress for her position. What she did not tell me, though, was that this was related to any incident with the director on July 3rd.
What she told you is that it was related to her relationship with Anthony Byrd, right?
This is my shorthand in the notes, where I said instead she wanted to leave because of issues with Anthony. I was talking about the July 3rd.
Oh, so when you wrote because of issues with Anthony, what you were saying is there was issues with Anthony as it relates to something related to the director of personnel.
What's the question?
The question is, you said because of issues with Anthony.
These are my notes. I didn't write, a full verbose statement here.
Don't you think it's important if you're conducting an investigation regarding director of personnel to say whether or not her real decision for leaving had to do with the director of personnel? Wasn't that easier to write in there as opposed to putting Anthony in there?
Objection argumentative.
Overruled. You understand the question?
I think so. These are notes. We then asked Bianca for a follow-up full statement.
I understand that, ma'am. But my question simply is this. You're the investigator, right? That was your job, to fully investigate this issue, right?
Correct.
And that investigation happened in a sweeping, 5 days? Well, really 4.5 days, because the letter was sent that morning. So 4 days you did this speedy investigation, correct?
We talked to the relevant parties in that time. Yep.
Right, and in 4 days, right? You did the investigation. We can agree to that, right?
Yes.
Okay, you didn't inquire about the extra miles. We talked about that. You didn't inquire about the fact that he put city and not Jeff City. You didn't inquire about that, right?
We did not inquire about that.
You did not inquire
Sorry,
about
I did
it.
not inquire about
Okay,
that.
and then you wrote in your report that the reason she decided to leave were issues with Anthony, right? That's what you wrote.
I wrote that. That's correct.
Okay,
This
fair
is-
enough, fair enough. Let's go to other parts of your investigation. That was the first meeting. In that meeting, it was Mr. Understall, Bianca, and you.
Correct.
And we talked about the fact that Mr. Boyd was not there, right?
Correct.
And that was on 8/19/2024 at 10 a.m., correct?
Correct.
Got about 1 minute.
Yes, thank you. And then you proceeded to 1:30. You had a meeting with the director, Mr. Jerry Boyd, and yourself, right?
Correct.
And at that meeting, Mr. Boyd asked for a letter of resignation, correct?
No. He didn't ask for a letter of resignation at the first meeting with Director
Well,
Gray.
did he ever ask for the letter of resignation?
When we told Director Gray later that week that we were going to move forward with a pre-termination letter, I don't recall him asking for a resignation letter, but we did not give the pre-termination letter until the next day.
And you don't recall him asking for her letter of resignation?
I do not recall that specific question. You'll have
Okay.
to ask him about
It
that.
could have happened, you just don't know.
I don't recall that specific question.
Fair enough. I think my time is up. Thank you.
All right. All right, then that, redirect then?
Yes.
Okay.
So let's just stay on Respondents Exhibit 28, the
Okay.
notes that you were just being asked about. You have that in front of you, right?
I do.
And those are your notes?
Correct.
Okay, prepared, as you were talking to the witnesses?
Correct.
Okay. I would move for the admission of Respondents Exhibit 28 into evidence.
I would object because it's latent with hearsay.
I mean, it was just put up on the screen, and
Well,
he's went into
all right.
fairly good detail about it.
All right, but as to specific questions, again, are you offering these for the truth of statements in the exhibit?
So they're not offered to prove the truth of the matter asserted,
All
but
right,
they're
with
offered.
that understanding,
Well, what are they offered for?
So they're-
Can I make an inquiry about that?
Go ahead, Mr. Harris.
Well, I mean, they're offered to show the listeners, actions after the statements that are in the report itself. I mean, she testified that they had to determine what to do based on what they learned in this investigation, and so this shows what she learned in her investigation, so it helps explain her actions and the actions of Mr. Boyd.
All right, and so that is the basis for which they're offered. They're not offered to prove the truth. In other words, this quotes different people or relates summary form, and the quotation marks don't appear to be used except for very few times. But at any rate, they're not offered to suggest that what is related here as having been said by any particular person, whether that's true or not. So with that limitation, in other words, your hearsay objection is sustained in that they're not offered for the truth of any of the statements, all right?
Fair enough. Thank
They-
you, Your Honor.
All right.
All right. And you were asked, repeatedly about not reporting Dr. Byrd to someone, right?
Yes.
So this case, let's get back to this. This is about Director Gray, right?
Correct.
So this hearing and the whole pre-termination process was not about disciplining Dr. Byrd,
Correct. It was not.
who is a subordinate of Director Gray.
Correct.
Okay, this is about Director Gray's conduct.
Correct.
And Director Gray is Dr. Byrd's appointing authority, is that right?
She is.
So if there was someone to report him to, it would be to the appointing authority.
Correct.
The appointing authority, who in this case is the one who engaged in the misconduct.
Correct.
Okay. You were asked about the city vehicle policy and whether the director had to, I don't know, scurry through a bunch of websites to find it. Remember that?
Yes.
Okay. So is it odd to you that after 2 years as the director, she wouldn't know the city vehicle policy?
Let me object.
Or that there is a city vehicle
Let me
policy?
object. I mean,
Sustained, Mr. Rollins. Whether it's odd to her or not is totally irrelevant.
Oh, okay, sure.
Irrelevant.
Okay, so you were asked if you're aware of anyone ever being disciplined or terminated for violating the city vehicle policy. You recall that?
Yes.
And, you didn't have any personal knowledge about that, right?
Correct.
Are you aware of anyone, any director, any department director, ever taking a city vehicle with a subordinate out of town to spy on their husband?
I am not aware of anyone else doing that.
Unprecedented?
Yes.
Okay. This issue over the number of miles that were used for the vehicle, and whether you looked into that, for this particular matter, that is, reviewing the conduct of the director of personnel, and what you had learned, based on the folks you talked to, did the number of miles that that car had been driven, did that factor into, what you were looking into at that point?
The most relevant factors were that the car had been checked out and had traveled, and that the director herself had confirmed that this had occurred.
And so learning that in fact had happened through that log, that it had been checked out by Dr. Bird, helped confirm to you what you had learned from various witnesses,
Correct.
including the director,
Correct.
who admitted it.
Correct.
Okay. And then you were asked about whether this business of Bianca lying about why she was gonna quit or not, right?
Yes, I was asked about that.
Did that matter as far as what you had learned about the allegation related to the director?
No, when Bianca told me she was going to quit, I had no idea about these other things that were on her mind or going on. I did know she was under substantial stress with her position at that time, so that didn't seem terribly odd to me. And then when she brought these forward, of course I understood that that was also a reason for her wanting to quit.
And again, the bottom line was that the director admitted the conduct. Is that right?
Correct.
Okay. And so whether Bianca was stressed about, the amount of work or why she was thinking about quitting, the director admitted the conduct.
What conduct?
What did the director admit?
The director admitted that she had taken a city vehicle with Anthony Bird to Jefferson City for personal reasons.
No further questions.
Few follow-up, short, sweet.
I think you need to tell us
Well,
what
she
it
just,
is you're following up on, because it was very limited redirect.
Well, he
So
opened
if
a
it-
few-
If it's limited to the redirect questions, yes.
okay, unprecedented, right? You were aware of the fact that there was an Elliott Davis interview of the mayor when she was the treasurer regarding the fact that she was suggesting improperly using an assigned city vehicle. You were aware of that, right?
I didn't work for the mayor,
Okay.
then treasurer at that
So
time.
you didn't see the Elliott Davis interview.
I don't know when you're talking about, but I didn't even leave in the city of St. Louis. I would
What
imagine.
about the St. Louis Recorder of Deeds allowing her husband to use a vehicle in which he had 2 accidents? Were you aware of that?
No.
Okay, so none of that. When you said unprecedented, you really were talking about the limited time you've been at the city, correct?
I'm saying, to my knowledge, it's unprecedented that someone would take a city vehicle with a subordinate to Jefferson City to spy on their husband. I was answering that question.
All right, all right.
To spy on her husband.
And you don't know if that was the reason she went to Jefferson City, right? You assume that that's the case, right?
That is what Anthony Bird told us.
And he has been identified as a notorious liar. That's the person you're relying upon to suggest that that was the reason, right?
Director Gray also said in her interview with us that she was not pleased with what she had found related to her husband in Jefferson City,
But what does that mean about spying on her husband?
that she had gone to see her husband in Jefferson City is what that confirmed for me.
Is that what she said? Or is that
She-
the conclusion you drew?
I concluded, based on her saying that she wasn't pleased with what she found in relevance to her husband in Jefferson City, that she went to Jefferson City to see her husband.
So that's an assumption on your part.
I don't know why anyone would mention their husband and what happened on the trip if they hadn't seen their husband
Well,
on
you
the
said
trip.
through her testimony, you heard her testify that she was trying to reach her husband, right?
I was here for day one of her testimony. I did hear that.
Okay, and she was trying to reach her husband, she couldn't reach him, right?
That was her testimony.
That's what
yes.
she said. And you don't think that might be some grounds to worry about where her husband is? If she couldn't reach you?
Sure, if you can't reach your spouse, I would
If
understand
you can't
worrying.
reach your spouse, you would be worried if you couldn't reach your spouse in Jeff City, wouldn't you?
If I couldn't reach my spouse, I would be worried.
Okay, exactly. And so her being worried, there's nothing atypical or uncommon about that, right?
There's nothing atypical about worrying about your spouse.
Well, you
Taking-
heard her testify that she went to retrieve some personal papers. Do you have anything you can share with us today to suggest that that testimony was not factually accurate?
She talked about going to receive personal papers using a city vehicle with a subordinate employee.
Right. And so let's tease that out. Let's just focus on the little piece about going to retrieve the personal papers. And of course, you know, based upon what was reported by the director, Dr. Byrd, that they conducted business all along the way. You're aware of that, right?
I'm aware that that's their testimony.
Okay, well, that's all we got. There was only 2 people in the car, right? And you don't have any other source to contradict at least that portion of the testimony, that they were conducting city business all along the way, right?
I don't have personal knowledge of that.
Okay, did you talk to some of those personnel that she suggested or Dr. Byrd suggested they were talking to all along the way? Did you interview any of those people?
I don't know who you're referring to.
Anybody in personnel regarding whether or not they were having conversations with the director and or Dr. Byrd as they were driving to Jeff City.
Let me object, and we're going way beyond the scope of the redirect at this point.
Sustain.
Let me do this. Let me say this. You talked about the fact that, and this is in response to his question, that the law, which shows this extra mileage, that would be the responsibility of the director of personnel as the appointing authority, correct?
Correct. She is
Okay.
responsible for
All right.
discipline related to her subordinates.
And you didn't report the fact that you all had obtained a document which suggests that there was an extra 488 miles. You didn't report that to her, did you?
As I've said, I did not report.
Okay. And you don't know if Mr. Boyd reported it to her, right?
I do not know.
Do you know when she actually saw this vehicle log showing city instead of Jefferson City and showing this extra 400 miles? Do you know when the first time she got that log?
I do not know.
Would it surprise you if it was a week or so ago or 2 weeks ago?
It would surprise me that an appointing authority wouldn't have wondered what their subordinate authority was doing with a car.
No further questions.
All right, that's it for this witness. This witness is excused. 11 o'clock. You ready to call another witness?
Call Jared Boyd.
Ms. Boyd, step up, face the clerk over there, and she'll swear you in.
Do you affirm or swear that the testimony you're about to give is the truth and nothing but the truth?
I do.
All right, you may proceed.
Good morning. Go ahead and state your name for the record.
Louis Jared Boyd.
And who's your employer?
I'm employed by the City of St. Louis, specifically the St. Louis City Mayor's Office.
Okay, what's your position?
I serve as Chief of Staff in the St. Louis City Mayor's Office.
Okay. And Sarah Baker is your deputy, is that right?
Yes.
And I want you to take a look at, I'm going to show him a document that we're going to mark as Exhibit 27. Okay.
Could I see it? Thank you.
Okay, just one. You got another one?
Can you tell us, you recognize Exhibit 27?
I do.
Can you tell us what that is?
It is a document that provides a delegation of authority, and it allows the delegation of certain types of authority, including personnel actions, appointments, dismissals, disciplinary actions, and other actions that can be taken on behalf of the mayor and signed by the mayor on the day that I started my position in the mayor's office, April 20th, 2021.
Okay, and then that document actually is double-sided. What's on the back?
It also includes a delegation of authority to Nancy Cross, Director of Operations, who started subsequently in May of 2021. And that delegation of authority is not as expansive. It only covers personnel actions.
Okay, so the one you mentioned for you that's dated April of 2021, as you indicated, that was That was around the start of your tenure there?
Yes, it was the first day of my tenure in the St. Louis City Mayor's office.
Okay, and then the one for Ms. Cross was the first day of hers?
On or around when she started in the mayor's office.
Okay. I would move for the admission of government, of appointing authorities Exhibit 27.
No objection.
All right, Exhibit 27 is admitted.
And so you were delegated authority over personnel issues starting way back in 2021, is that right?
Yes,
And then Nancy Cross was also delegated some little more limited authority back in 2021?
yes,
And that included issues related to cabinet members, including the director of personnel?
yes,
Okay. And then take a look at the binder to your right, Exhibit 11.
yes,
So it's appointing authorities Exhibit 11.
yes,
Do you recognize that document?
yes.
What is Exhibit 11?
It is an updated form for delegation of authority.
Okay, and that's a delegation of authority to whom?
Both Nancy Cross and myself.
Okay. I don't think this has been admitted, so I want to move for the admission of Exhibit 11 into evidence.
No objection.
All right, Exhibit 11 is admitted.
Okay, and that one's dated August 23rd, 2024, correct?
Yes.
And what was the purpose of that delegation of authority?
There was some just concern that we had changed the direct reporting structure of the Director of Personnel and wanted to ensure that our documentation reflected the fact that both the Director of Operations and the Chief of Staff both had interactions, but primarily the Chief of Staff had interactions with the Director of Personnel as to allow for discipline.
Okay, and so the delegation of authority does clarify then that you are delegated as the director's appointing authority, is that right?
Let me object and cause for a legal conclusion.
Is that what it purports to do?
Same objection.
Overruled. That's
I-
what the witness understands that it purports to do is the question.
We sought to formalize the change in reporting structure to reflect that the Director of Personnel originally reported directly to the Director of Operations and subsequently was reassigned to report directly to myself.
Okay. I mean, it reads that, I hereby delegate, and then it has you guys' name in it, the authority to act in my stead as appointing authority. Is that right?
Yes.
Now I want to direct your attention to, you've been here throughout the course of some of the testimony during this hearing, right?
Yes.
Today and prior days.
Yes.
So I want to direct your attention to a meeting that you had on August the 19th, 2024 with the personnel director, okay?
Yes.
Why did you end up meeting with her that day?
I was informed by my Deputy Chief of Staff, Sarah Baker, that there was a potential issue with regards to the personnel director and that potentially some of her employees reported some concerns that they had reported to Sarah Baker.
Okay. And you personally did not speak with these employees, with Bianca Lambert or John Ernestal, is that right?
I did not.
And so what you learned from Sarah Baker, was that the first time you had heard about any of this?
Yes.
And so based on what you learned, you decided that you were going to, you needed to meet with the director, is that right?
Yes.
And going into the meeting, did you have any, thoughts or plans or anything going into that initial meeting with the director of what this was going to be about?
My hope that it was not a substantial concern that would allow us to continue with critical operations and that I could get back to other aspects of my job that were pressing at the time, but that we had a duty to investigate or learn more about the alleged complaint.
You were hoping that, you know, there's hopefully no there there.
Correct.
And so you have this meeting with the director and with Ms. Baker, is that right?
Yes.
Was that in your office?
Yes.
Was anyone else present for that meeting?
The meeting consisted of Sarah Baker, Director Gray, and myself.
Okay. And did you ask her about the information that you had received regarding, you know, her conduct in relation to this city vehicle?
Yes. The initial concern was that Director Gray took a subordinate on an inappropriate trip to Jefferson City, and in exchange, said employee received a reallocation or raise. So that was the initial concern that had been voiced to Sarah Baker, and we were charged with investigating.
Okay. And so you raised that issue with her? With
Yes,
the director?
and she immediately admitted to taking the trip to Jefferson City.
Okay. Did she say why she took the trip to Jefferson City?
No, not initially. She initially admitted to taking the trip, but quickly pivoted to saying that her subordinate, Dr. Bird, had done similar conduct all the time, and that, you know, she relied on him for the trip, and immediately tried to play a recording of a conversation that she had with him. And at that point in time, I asked her to not play said recording, that we wanted to learn more about the actual trip.
Okay. And why did you tell her not to play the recording?
I was, quite frankly, caught off guard by her offer to play a recording that was made that another employee didn't know about and wanted to learn more about the actual trip.
Okay. All right. So you want to learn more. So I take it you asked her questions about, you know, give me details of what was the purpose of the trip?
Yes. Wanted to understand the context for the trip, particularly because it occurred the day before the 4th of July, and just had difficulty understanding the reasons for the trip or basic facts surrounding the trip.
Okay. And you said that she started saying that that Dr. Bird does this all the time with city vehicles?
Yes, that he uses city vehicles for personal use frequently. That was said immediately after admitting to taking the trip.
To the best of your knowledge, you understand that the director is his appointing authority.
Yes.
To the best of your knowledge, has she ever disciplined him about, you know, taking a vehicle for personal reasons?
I am unaware of any discipline of Dr. Bird for violations of the personal vehicle policy.
Okay. And so she indicated to you that she was unaware of this policy?
Yes, at said time of taking the trip.
Okay. And did she ever tell you, give you any explanation of the reason for the trip?
Not necessarily. She vaguely stated that she went on the trip to retrieve personal documents, and I asked several times kind of what those personal documents were for or why they were so important to gather the day before the 4th of July, and she refused to actually provide what those personal documents were or other details around the trip. She kept reverting back to went to go and find personal documents.
Okay. And at some point during the conversation, did she ask for confidentiality?
Yes.
Okay. And how did you respond to that?
I could not provide her with confidentiality.
Okay. And then what happened after that?
We continued to discuss the trip or attempt to discuss the trip, and continue to not really get substantive kind of details around the trip. The other allegation that we were concerned about is that Dr. Byrd received a reclassification or a raise as a result of going on this trip, and she talked about how that reallocation was in process before the trip occurred. So that was her, retort to that allegation, which we would have to subsequently investigate, but at least that provided us with the means of investigating that aspect of the complaint.
Okay, and so sounds like you pressed a little bit about what these personal documents were and never really got a response.
That is correct. I could not understand why the trip was so urgent at that point in time.
Okay, and so I take it, did the meeting end after that?
It ended sometime after kind of discussing the nature of the trip and just saying that we're going to have to do additional follow-up on this complaint.
Right. So you talked about going in. You were hoping that there's going to be nothing there, and we can just kind of move on with doing our work, right?
That was my hope.
Okay. But after having spoken with the director, did that change?
It did change. The combination of vagueness around the trip, the willingness to pin blame so quickly on her subordinate, and the willingness to immediately try and play a recording of an employee who did not know he was being recorded, all were concerning to me.
Okay. And so after meeting with the director, did you also meet with Dr. Byrd?
That is correct.
Okay. And without going into any, a lot of detail, I mean, we've heard a lot of detail throughout the hearing, but did Mr. Byrd, in his statement to you in the interview, confirm the details of what was learned from Bianca and John Understall?
He confirmed that he did, in fact, take a trip with the director to Jefferson City.
Okay. All right. And take a look at Exhibit 28 of the respondents in the respondent's binder. And turn to the second page of that exhibit. And those are, it's been established that these are notes of Sarah Baker, correct?
Yes.
And it lays out on that second page, her notes of what Dr. Byrd said in that meeting. Is that right?
Yes.
Okay. And does that comport with what you remember of Dr. Byrd saying in that meeting?
Yes, in the sense of these were her notes for the conversation that we initially had with Dr. Byrd.
Right. Okay. And so you've gotten this report from Sarah Baker about what these employees said. You've met with the director and had her admit at least that she took this city vehicle with the subordinate during work time for personal reasons of getting some personal papers or something, and the other concerns that you had, and then you've had this conversation with Dr. Byrd. So at this point, are we back to there's no there, or is this getting even more concerning?
This is getting even more concerning based upon the involvement of a subordinate who unknowingly was thrown into this trip.
Okay. And whether he was unknowingly, whether he knew or not about whether it was a personal trip, I assume you don't have any personal knowledge of that.
I don't have any personal knowledge that Dr. Byrd knew the contents of the trip. I would say that I asked him if he knew the reasons why he was going to Jefferson City, and he did not seem to know that the actual kind of reason for going to Jefferson City when he started the trip.
Okay. All right. And then based on these meetings you had and what you've learned, we understand that you all requested a written statement from the director. Is that right?
That's correct.
And then if you look at Exhibit 2 in the binder to your right, just take a look at that. That's the statement that was provided?
That's correct.
And then did you all inform the director after that you would be moving forward with a pre-termination process?
Yes, we initially met with her on Thursday of the week of the 19th and provided her with our assessment of the situation and wanted to give her a day's notice before actually delivering the formal pre-termination letter.
Okay. And you probably saw that Ms. Baker was asked whether or not you asked the director to resign. Did you ask the director to resign?
I did not ask her to resign. I provided her with the opportunity to resign. I know that the process is a uniquely public process and wanted to provide her with the opportunity to avoid the public nature of this process.
Right, because the charter requires a public hearing, right?
Correct.
And so take a look at Exhibit 1 in our bind, in the one to your right, sorry. Appointing Authority Exhibit 1. Is that the pre-termination letter that you gave to the director?
It is.
Now, you've been here, and opposing counsel has made much of the September 3rd date that's in that letter. Why is that date in the letter?
That date is in the letter as a tentative date that the chair of the Civil Service Commission thought he was available and other commissioners could be available. I was very cognizant of the former chair's schedule because he is a very busy attorney with a national practice that requires a lot of travel. So my first concern with the hearing is that, one, his schedule is incredibly busy, and then two, the staff that's usually involved in scheduling a hearing had been implicated in this particular complaint.
So when you're talking about Mr. Byrd, is that right, Dr. Byrd?
That's correct.
He would be someone who would be involved in scheduling the hearing.
That's correct.
But he's a witness in the whole thing, right?
That is correct. So I thought that there were pretty clear conflicts of interest and that in order to move forward with the process that we would have to work directly with the Civil Service Commission in actually scheduling a hearing.
Right. Because here you have the director, who is the one accused of malfeasance, her subordinate, someone she works closely with, who went on the trip with her and is therefore a witness. These are the folks who are normally involved in the scheduling of these kinds of hearings.
Correct. If a prosecutor is charged with a crime, it's routine that another jurisdiction steps in, because if you are implicated, there's a loss of impartiality. So I took the unique step of working directly with the commission to try and schedule a hearing based upon their availability.
Okay. And, I mean, I take it it's difficult to get a group of commissioners who have their own lives and jobs outside of serving on a commission together at one time to have a hearing.
I'm objecting. I've given them a lot of latitude, but there's a lot of leading questions we got going on.
Sustained is the leading.
Did you, let me ask you this. Have you had conversations then or contacts, and let me go back. you mentioned the chairman. You're talking about the chairman at the time?
The chairman at the time, Dean Caperi Daibo.
Okay. And so did you have communications with him and or any other commissioner regarding trying to set this matter for a hearing?
My communications were primarily with Dean Caperi Daibo, based upon, like I said, he's incredibly busy, and I'm busy, so attempting to reach one another is a challenge. We played phone tag for a considerable amount of time based upon his schedule and my schedule, and we are also friends as well, so being able to catch up and check on each other's families.
Okay. All right. So why even engage in this pre-termination process? So you've learned what you've learned through who you've talked to. Why choose the pre-termination process in this letter? Why go that route?
It seemed to be our only option based upon the conduct that was discovered during our investigation. It seemed so. The violation of the vehicle policy combined with unknowingly involving a subordinate with surveilling or putting in a precarious position made this a unique instance that we really didn't have a choice to deal with other than with pre-termination.
And were you concerned about whether or not it seemed that the director had taken accountability?
It seemed as if she avoided accountability by pivoting immediately to her subordinates' previous conduct with regards to cars and trying to say that she was planning on self-reporting an incident, which did not occur.
Okay. Well, what about this business about, hey, she reimbursed the city, according to her, that she paid this money back for the use of the car for the trip, the round trip from St. Louis to Jefferson City. Doesn't that make it better? Doesn't that resolve things?
No, you don't get to reimburse the city after you get caught, and the underlying offense wasn't just about the mileage. It was about unknowingly taking your subordinate and putting him in a precarious position. As a leader of a department, as a leader of our city's HR department, that seemed to be a gross violation of judgment, a violation of our code of conduct, and went into the determination around her pre-termination.
So then this isn't just about, this $170.30 figure that they've thrown around.
Objection.
Absolutely not.
Leading.
Sustained.
Is this about the $170.30?
The pre-termination decision is based upon the violation of the vehicle use policy and the violation of our code of conduct and putting a subordinate in a precarious position without their consent, putting them in danger, and not taking accountability for the precarious position that you put your subordinate in.
And you mentioned the code of conduct. Do you also mention that in the pre-termination letter?
I do.
Okay. Take a look at Appointing Authority Exhibit 3. Is that the code of conduct?
It is?
You've seen that before?
Yes.
That was issued by the mayor, is that right?
I'm not sure of the origins of the original issuance, but it is something that governs city conduct,
Okay. So
employee city conduct.
Right. Applies to mayoral appointees as well?
Yes.
Okay. I want to move for the admission into evidence of Exhibit 3.
No objection.
Exhibit 3 is admitted, no objection.
If you look at the, kind of the very first line in that code of conduct, does that say the city employees have responsibilities to, and it mentions various groups, including the public?
Yes.
And what, can you read into the record that next sentence where it begins, these unique?
These unique responsibilities require each of us to act with honor, faithfulness, loyalty, fairness, and due diligence in conducting our job duties, and require us to report improper, unethical, or unlawful behavior.
Okay, and can you go ahead and read that next sentence that says city employees must?
City employees must at all times comply with all applicable laws and regulations. Failure to comply with all applicable laws and regulations or unethical behavior in connection with the performance of an employee's duties will not be condoned or permitted. The city does not permit any activity that fails to stand the closest possible public scrutiny.
Okay. And then taking a look again at Exhibit 1, which is the pre-termination notice. In the first page, third paragraph, that's where you mentioned the city's code of conduct, is that right?
That is correct.
Okay. And you say in that letter, the example set by the conduct described herein violates the city's code of conduct, is that right?
That is correct.
Okay. Are appointing authorities expected to set an example to their subordinates?
That is correct, and that is reiterated several times in the Code of Conduct in terms of unique responsibilities, not just for city employees, but for supervisors.
Okay. Have you, we talked about your communications with the former chair, Daibo. Did you ever tell him how he should rule in this matter?
No,
Did you ever tell any of the commissioners how they should rule in this matter?
no.
1 second. That's all I have.
All right. Mr. Norwood, cross-examination, 1033, I'm sorry, 1133, and 1133 plus 35, that'd put us just after noon, if my math is right.
Just so I'm keeping tab. So what time exactly? So I
Well,
know, 'cause
right
it'll be
now,
erased.
I have 1133.
Right.
We'll call it 1134. By the time we quit talking, it'll be another minute.
Okay.
So add 35 to that, and if my math is right, it'll be 9 minutes after noon.
Thank you.
Now, as I had said before, we were planning on breaking at noon, right? Correct.
Correct.
So, I would assume maybe we would finish the direct exam if we can. In other words, go the extra,
The cross.
I'm sorry, the cross exam. Go the extra 9
Yes.
minutes, 10 minutes, and then we'd break and come back for the redirect.
Yes.
After lunch, all right?
Yes.
So gentlemen, as long as this goes smoothly, that's the way we'll proceed.
Thank you. Your Honor.
Thank you, Mr. Norwood.
Okay, Mr. Boyd, let's turn to that employee code of conduct. And you talked about it. It requires each of you, meaning every city employee, to honor faithfully, loyalty, fairness, due diligence, correct?
The Code of Conduct does require employees to, abide by certain behaviors.
Okay, let's turn to page 4 of that code of conduct. There's a section called honesty. You're familiar with that portion, aren't you? Okay, the last page.
Okay,
You see that, honesty?
I see the honesty section.
Okay, it says city employees shall be completely honest in their dealings with the public, elected officials, appointing authorities, supervisors, and fellow employees, correct?
That's what it states.
That's what it says. And it says lying in any form, omitting some facts or exaggeration undermines the fundamental trust that must exist between employer and employee and has no place in public service, right?
That's what it states.
That's what you're bound by, right?
That's what it states.
And that's what you, as the chief of staff to the mayor, are bound by, right?
That's in the code of conduct, yes.
Okay, all right. Now let's turn to my binder, the thick binder, Exhibit 12. Let's take a look at that. It's already in evidence. What is Exhibit 12?
January 2nd, 2025, are we talking about the same exhibit?
Yes, that's
Okay.
the one.
It's an email to Sonia Gray.
From you, right?
Correct.
On January 2nd, 2025 at 3:25 p.m., correct?
Yes.
And in the ray line, you say, personal attorneys on city premises, right?
Yes.
And the attorneys you were talking about was me and my team, right?
Yes.
All right. And then you say to the director, Sonia, we received a complaint this afternoon that your attorneys are spending the day in the personnel department. Do you see that?
That's correct.
And that was a lie, right?
I saw you walking out of the court, one. Two, I did receive a complaint that the attorneys for Ms. Gray were here, and I was seeking to either confirm that issue or be able to put that issue to rest.
What issue to rest? This is a public courthouse. I come in this house thing every day. I go through security just like all the other lawyers. You're saying that we had no right to be in this building? Is that what you were communicating to this director?
No, I didn't have an issue when I saw you and your team that day, but I did receive a complaint
Who complained?
from
Who complained?
Dr. Bird complained.
What did he say?
He said that the attorneys were there and it made some folks feel uncomfortable.
He made people feel uncomfortable. A threatening African American walking around a public courthouse, is that what made people feel uncomfortable?
Objection.
I withdraw the question. What was the threat?
That's exactly why I was having to look into it, because an employee expressed discomfort.
Okay. Dr. Bird, the notorious liar, expressed discomfort about me being in a court building. Right?
I simply was trying to, I said, investigate said complaint.
Okay, and you investigate, you say spending the day. That's what you communicated to her. Right?
That was the substance of the complaint.
And that was a lie, right?
I don't know.
You didn't know whether, you didn't care. You just sent her a letter saying your lawyers are spending the day in a federal courthouse. I mean, a city courthouse. That's what you communicated to her, right?
I communicated a question,
To intimidate her, right?
not to intimidate her, to inquire.
Is there any law that prohibits her from having her lawyers visit with her in her personal office to address charges that you have levied against her?
I don't know if there's a prohibition, but the complaint centered around discomfort.
Discomfort, what, did you inquire further? What made you discomfortable or discomfort by the fact that lawyers were assuming that was the case? Because in fact, and I'll testify, and I have my paralegals who were here, we were in this room getting the lay of the land. You don't know how long we were here, do you?
I do not, and
you
I was
didn't
not,
care
I
because
simply,
you said spending the day. That was a lie.
I simply asked a question which I didn't receive a response to.
And you're saying Dr. Bird told you we were spending the day.
I received a complaint, and I relayed that complaint to the director.
Okay. And your investigation consisted of hearing him and then firing off this letter within, I saw you, what is around 1 o'clock? So within an hour and a half, you fired off this email to my client, right?
As you stated, I actually did see you coming out of the court
Right,
that
you
day,
saw
and
me
I was not concerned about your presence.
Did I look like I was threatening?
You do look threatening, Ron,
Yeah,
actually.
sometimes.
Yes.
All right?
Yes.
Did I look threatening to you? Didn't we
Yeah.
talk?
Yes.
Can I object? I mean, we're like far afield of what's relevant here.
No, all right. We don't have a question right now. What's the question?
The question is, I saw you. We exchanged pleasantries. There was a
Sure.
camera there, so if I did something improper, I'm sure the camera would have picked it up, right? We just exchanged words, and I was off on my way, right?
As stated before, I was fine with seeing you come out of the courtroom, and I had several other things to do when I got back to the office when a complaint came to me.
How did it come to you?
I got someone related to me. I can't
How
recall.
did he call you?
I cannot recall how I learned of this, but
Did he email you?
like I said, I can't recall.
Did he send a carrier pigeon to you?
Asked him
How did he
answer.
notify
He said
you?
he could not recall, Mr. Norwood, when you asked him. Okay.
Fair enough. Let's talk about this delegation of authority. Right? You talked about that. Let's look at Exhibit 27. Right? And that's the delegation, what you say was a delegation of authority, that was signed by the mayor.
I'm sorry,
on
which exhibit?
27 of there, it was a loose exhibit, that one, yeah, that's the one.
Yes.
Exhibit 27, actually, this is the delegation of authority for employees of the mayor's office, right?
Yes.
She's not an employee of the mayor's office, is she?
The director is someone who reports directly to the mayor's
She
office.
is not an employee of the mayor's office. Can we agree to that?
That is correct, but that's
Okay.
I guess, characterization of the powers that are in this form.
This says employees of the mayor's office, and you said she's not an employee of the mayor's office, right? We agree
That's
to
correct,
that, right?
yes.
Okay, so this didn't give you authority to investigate her as written, did it?
I am her appointing authority and am empowered with the ability to work on behalf of the mayor's office.
This didn't give you that authority, though, right?
Like I said, I work on behalf of the mayor and am empowered to carry out decisions on her behalf.
Any power you want. You can just walk around and send emails threatening people because their lawyers come in the building.
Objection,
That's your
argument,
testimony. I withdraw the
sustained.
question. Let's look at the other delegation of authority in this other binder, Exhibit 11. Let's take a look at that. You got that one?
Yes,
And that's different than this one, right?
yes,
Because that one talks about employees of the mayor, right? Right? Mayor's office, right?
yes,
This one says employees of the Department of the Mayor's office and all mayoral appointees, right?
yes.
So that swept in the director, right?
That, I believe, is a belt and suspenders approach to just ensuring that there is clarity around the delegation of authority.
You're a lawyer, right?
Yes,
And you understand the legal semantics of the mayor's office employees versus mayoral employees, don't you?
I'm also a supervisor of several cabinet officials, including the director. So
But you're a
it's
member
been
of the bar.
understood. Yes, it's
And
been
you have
understood.
ethical obligations under those bar obligations, right?
Yes,
And that includes being truthful and honest as well, right?
yes,
All right. And this authority that now expands to include the director of personnel, you hadn't done it before April of 2021, right? The mayor hadn't done it before, right?
as I stated before, it was very clear to the director, to the mayor, to the cabinet, who reported to whom. And it was clear to the director that she reported directly to me.
This doesn't deal with reporting. This original one, Exhibit 27, is the official document that purports to give you authority to do whatever on behalf of the mayor, right?
Yes,
And
it's
this
signed
one-
on the first day of
It's on the
service.
first day, and it only gave you authority over the mayor's office employees, right? And then we expanded to include mayoral appointees, which happened to sweep in the director of personnel, right?
Mayoral appointees includes the director of personnel.
Okay. So before that, you really didn't have authority to investigate her when you had those interviews, when you browbeat her in that office of yours. You didn't have that official authority until August 23rd, 2024, according to the delegation of authority, right?
That's incorrect.
To the mischaracterization of testimony, browbeating, that's his characterization. There's no evidence of browbeating anybody.
That's incorrect.
Mr. Norwood, it's a compound question.
I will rephrase the question. When you politely invited her to your office in order to drop this bomb on her about termination, you didn't have the authority because that authority hadn't been signed by the mayor until August 23rd, 2024, correct?
Incorrect.
All right, that's what the document says, right?
The document doesn't talk to the ability to conduct investigations.
Okay.
The ability to conduct investigations is something that an appointing authority can do and utilize other staff to do so.
And or orally, just say, go out and investigate somebody. That's your sworn testimony as a lawyer today.
I'm sorry, can you rephrase the
I'll
question?
withdraw the question, okay? You already had a delegation authority, so why do we need to sign this? What is this about? You already had it, according to you, right?
We had a delegation of authority that allowed me to carry out certain duties on behalf of the mayor. And as I stated, this was a belt and suspenders approach to that delegation of authority.
And that belt and those suspenders you just happened to put on after the investigation and the morning that you delivered this pre-termination letter to my client, correct? That's when the belt and suspenders came together, right?
It is correct because I've never had to issue a preterm letter for someone.
And really what this case is about is this, right? $170.30 that she's reimbursed, right? That's the issue, right?
No, the issue is that the director violated the code of conduct and
And what portion of the code of conduct?
I believe it's in my letter.
What
You have-
portion though? What specific portion? You got the code of conduct.
Sure.
Tell me where it is so we can all read it together.
Let's see, what exhibit is the letter? Is it one?
Yes, exhibit 1 in that binder,
Okay,
skinny binder,
sure.
the other binder, the other,
Oh, this one? Gotcha. Okay. I'll draw your attention to paragraph 3. The city's code of conduct also states appointing authorities are responsible for setting an example of competence and appropriate ethical behavior, that all city employees must meet acceptable standards of performance. But prior to that, basically ethical, setting an ethical example.
and what's unethical about her asking her subordinate if it was okay for him to drive her to pick up some personal papers while they were conducting city business? What's unethical about that?
She didn't obtain his consent to take that trip for the reasons that the reasons that the trip occurred.
She told him that it wasn't all city business, right? You saw those emails, haven't you? You were in the deposition when we went over with Dr. Bird, right?
But she didn't actually state why, what the trip was for.
It was personal. There's no dispute about it. It was a personal trip, right?
It was a personal trip in which a subordinate was put in a precarious position.
Do you know if she intended to put him in a precarious situation when she went to pick up her papers and come back to St. Louis?
I don't know her intentions,
Right,
but
right.
what occurred is
Right, now,
that
let's
she
stop right
put
there. Stop right there.
her subordinate in a
Let's stop
precarious
right there.
position.
Let's stop right there. You don't know what her intentions were. We can agree with that, right?
Her intentions for what?
For going to Jeff City for whatever reason. You don't know, as you say today, what her intentions were. We can agree with that, right?
Her subjective intentions?
Yes.
Or
Or objective any intentions. You just said it. You don't know what her intentions were, right?
I did not just say anything.
Okay. Let's do this the hard way. As you sit here today under oath, do you know why she went to Jeff City on July 3rd of 2024?
Well, I think there is a dispute as to why she went to Jefferson City,
That's
and
not my question, sir. I'm asking you under oath. As you sit here today, do you know why?
I don't have a definitive answer because she refused to provide me with clarity on the reason for said trip.
You're saying she had an obligation to tell you about her personal business when she admitted that it was a personal trip? Is that your position here? Is that where the city is in this thing?
I, quite frankly, did not want to delve into her personal life, but because she used city resources to effectuate issues in her personal life, and because she put a subordinate in danger or in precarious position, it became my business.
Okay, and did she knowingly put him in a precarious position in your view of the world?
I don't know what probability she thought of kind of the precarious nature of the position she was going to put him in, but there was a likelihood that this employee was going to be put in a precarious position.
Okay, let me unpack that for a minute. First of all, from the vantage point of the commission, right? If the commission were to believe her testimony that she went to retrieve personal papers and killing two birds at one stone, taking care of city business all along the way, and the objective being retrieve those personal papers and go back to Jefferson City, if that's what they believe, they have the opportunity to believe what they want to believe. In that circumstance, how is he put in a precarious situation?
First, I would say that conducting personal business in a city vehicle is immaterial. If I drove to Disney World in a city vehicle and was making conference calls, I'd still be violating city policy, right?
Okay, all right, check. Okay, but back to my question, though.
Sure.
Is that putting him in a precarious situation if the mission was to kill two birds with one stone? We got a lot of business to cover. We're going to a holiday weekend. I'm going to go get my personal papers and come back. Let's assume that's the case because that's what the testimony is. Is that putting him in a precarious situation?
Well, the precarious situation came from potentially surveilling her husband.
Well, but that's assuming that's the case. Let's work on my hypothetical because the testimony is she went to retrieve papers. So let's stay there. You were in law school. You know how hypotheticals work.
Let me object to the speculative nature of this line of questioning.
It's not speculative because we have
All right,
testimony.
overruled as to the line of questioning. You'll have to wait until you hear a question and then make a specific objection.
Assuming that's what the testimony says, and assuming they believe that, my question to you simply is, how is that putting Dr. Byrd in a precarious situation?
And I'll object is asking the witness to assume, meaning to speculate.
Well, he is speculating because he just testified that she went to catch her husband cheating.
All right, the objection is overruled, but do you understand the question?
I do not.
So you'll
Okay,
have
let
to
me ask it
state the
again.
question.
Okay, you remember law school, right? They gave you a hypothetical. Let's assume, as she's testified, that she went to retrieve personal papers, and the objective was to get her personal papers out of her vehicle and return back to St. Louis. You follow me there? That part of the question you understand?
Can you help me understand what personal
It
papers
doesn't
are so
matter. Like
important
you
to
said, it doesn't
obtain
matter. Let's
the
say
day
she-
before the 4th of July?
Let's say she went there to get baseball tickets out of her car. Let's assume that to be the case. Okay, let's take the personal papers out of it. If that is the case, what is it about going to get those baseball tickets placed Dr. Byrd in a precarious situation, in your view?
In my view, or what actually occurred?
In your view of my hypothetical.
In your view of the hypothetical that there was no conflict or that
No, you
What-
said, I believe you testified, that the reason this stood out, that it's more than just $170 in change, is because she put Dr. Byrd in a precarious situation. That's what you testified to, right?
yes.
And I'm trying to understand that if, in fact, she was going to retrieve papers, in your view of the world, how is that her putting him in a precarious situation? That's all I'm asking.
Well, the
You know it's
papers,
a violation of policy that she didn't know about. Okay, we can check that. But we're talking about this precarious situation that you described.
yes.
Guess what?
Yes, in the sense of I'm listening to what you're saying.
Okay, so in that scenario, as testified, if that were the reason, and she was taking care of business all along the way, and the intent was to conduct business all along the way, does that change your view of whether or not she put him in a precarious situation?
As I stated, I understand, I guess, your hypothetical, but the facts or the testimony of others led me to believe that her subordinate was placed in a precarious situation.
Okay. Whether or not she knew it or not.
Whether or not she knew he was
Going
placed in a
up there,
precarious position,
anything other than retrieving her papers and coming back, a round tripper, whether or not that would have placed him in a precarious situation.
if that involved a confrontation with her spouse, potentially so.
Well, but do you know that she intended to have any confrontation with her spouse or even see her spouse?
She's testified that she went to go find him.
When did she testify to that?
I thought that's what she stated, that,
Well, the record will speak for itself.
Okay.
I thought the record said she went up there to retrieve papers, and she tried to track him down, and she couldn't, right? That's what you were here during that testimony, right?
so you're saying that going to find and trying to contact are two different things?
No. What I'm saying is that you heard her testimony. She said she went up there to get personal papers. You heard that part, right?
And that she tried to reach him while she was on the trip, correct?
Well, she was in Jeff City. He's in Jeff. They're in Jeff. They're in love. I mean, doesn't that make sense?
I don't know, because like I said, I asked about the actual kind of contents of the trip and was provided with vague facts.
Personal papers,
Yes.
baseball tickets, right? Even though she said, I didn't know about the policy, but I acknowledged the violation. And in fact, when she came to you, she acknowledged the violation because she read the policy and determined that it was a violation, correct?
Yes.
All right, and that's what she told to Bianca, according to Bianca, right?
I was not in a part of the conversation with Bianca, but I understand that's what she did say
So she fessed up, right?
after being asked if she did something wrong.
After being asked by whom?
By Bianca, correct?
Okay, so, and at the time, if she didn't have the policy, she would have known whether or not she did anything wrong or not. If she didn't have the policy, if we believe that part of it, right?
I don't know if that's to be the case, because it's pretty customary to use cars for business purposes, not personal purposes.
Okay. My point is that in your letter, you say that the policy is available online, right?
Yes.
Okay, which means that you don't have anything you can share with us today to suggest that she was provided with a copy of that policy, correct?
I do not.
Okay, so all we have is her testimony. She says, I didn't know about the policy, and she got a copy of the policy. When she read the policy, she fessed up. She didn't try to hide it, did she?
She admitted to violating the policy.
Right, okay, once she read it, right?
As I stated, she immediately confessed to violating the policy after we asked her if she had violated the policy.
You know, based on her discussion with Bianca, that she had made arrangements to go see the comptroller to reimburse the comptroller for the mileage. You knew that, right?
I did not. At the time of having my initial conversation with her, I had no personal knowledge of her conversation with Bianca. So my conversation with her on the 19th was my first, I guess, discussion with her about the policy, or knowledge that she may have violated the policy.
Okay. And when you and Sarah interviewed her, or rather interviewed Dr. Berg, he told you that it was all wrapped up by 9 p.m., right?
I don't recall if
Okay,
there was a
let's take
time
look
placed on that.
At the investigative summary, which is in the manual 28, in the big, thick manual. Let's take a look at that. And take a look at the third bullet point from the bottom. I'll read it. The first sentence, it says, Byrd finishes transporting Director Gray around 9 p.m. That's what he told you then, right?
That's what Sarah wrote. I remember the conversations, but these are her notes.
You think Sarah got it wrong when she wrote 9 p.m.?
I don't think she got it wrong, but this was Anthony's account that she put in a note. So
Well, that's all
I
we
would
got.
say I recall him saying that the trip essentially went into the evening.
And 9 p.m. is in the evening, right? Essentially.
Yes.
Right, okay. And that's what he told you then. All right. And so then you met, well, let me do this. Let's look at that log, that vehicle log, which is in their binder. I believe it's exhibit 13. All right, and you've seen that document before, right?
Yes.
That is the vehicle mileage log for Dr. Anthony Byrd, right?
Yes.
And in there, Dr. Byrd said his destination was the city, right?
That's what's stated.
Okay, and you saw that when you read it, right?
Yes.
And did you ask him why he put down the city when he knew he was going to Jeff City?
I did not have the opportunity because this was obtained after Dr. Byrd was interviewed.
Okay, all right. You have the opportunity for months after that, though, when you saw city down here and you knew they went to Jeff City, right? You had a lot of opportunity between August 23rd and today to investigate this false entry about the city, right?
Actually not. I am not Dr. Byrd's appointing authority, and he thwarted several attempts from our office to actually receive text messages or other information with this investigation, and really had no way of obtaining that information. The request was made to his then appointing authority at the time, Sylvia Donaldson, and he actually did not respond to our request for text messages.
Well, but you didn't have to talk to him to know this was a lie because he went to Jeff City. We knew that, right?
But I did not actually have the power to investigate. I did not have the power to discipline him, and as stated, had difficulty obtaining information from him for this investigation.
You had the power to report to his appointing authority that you found a document that suggests he falsified a record, right?
I did work with his appointing authority at the time to raise concerns about the trip, but also, like I said, to try and request her assistance in obtaining information about the trip, which I was unsuccessful.
You did not alert his appointing authority about the fact that this record was falsified by suggesting that this trip was limited to the city of St. Louis, correct?
For clarification, his appointing authority was Sylvia Donaldson while the director was on medical leave, and as stated before, raised concerns about the trip and requested information from said trip, and was denied additional information from the trip.
Did you communicate to her temporary appointing authority, that you had evidence suggest that he falsified this document? That's a yes or no question.
I can't recall if I spoke about the document specifically, but I did raise concerns about his involvement with the trip, and I expressed the need to get additional information from him with respect to the trip.
All right, let's move away from the trip now. We're now on the 4th of July. Right?
This is actually the trip.
No, I understand. But now let's move to the 4th of July. Anthony still had the vehicle, right?
It states that the vehicle was returned after the 4th of July.
So he still had the vehicle on the 4th, right?
Yes.
And he drove an extra 488 miles between the time he took it out, beyond the 230 miles of Jeff City. Another 488 miles, which would suggest to you that he traveled somewhere, right?
Yes.
And you knew that when you looked at this document, right?
The in time did appear to be longer than a trip to Jefferson City.
Much longer, 488 miles. That's a lot of much. That's a round trip to Kansas City and back, right?
If you say so.
No, I'm asking you. You're the investigator, right? You saw this. You ordered the log, right?
Yes.
You saw it. You realized that there was an extra 488 miles in there, right?
Yes.
And you didn't have any indication that he was driving around the block on city business for 488 miles, right?
I do not supervise Anthony, so I don't know the nature of the additional mileage.
But you have an obligation to report misconduct by the code of conduct we just read, right?
As I stated, I let his supervisor at the time know, Sylvia Donaldson, that
Answer
there
my
were
question.
concerns
Answer my question.
regarding his involvement in the
Answer
trip.
my question. You have an obligation under that same code of conduct to report this if it comes your way, whether you're the appointing authority or not. Isn't that true, Mr. Boyd? Isn't that true?
I would say that I raised this with his supervisor at the time, that there were concerns regarding his involvement with the trip and that we needed additional information to effectuate an investigation.
Did you tell her? Did you provide a copy of the law?
I cannot recall, but I certainly, like I said, raised this issue with her several times and had to go through her to try and request information about this case, and was not provided with full cooperation.
As you sit here today, you cannot testify that you provided her or the director with a copy of the law.
I can testify that I have not provided this to the director, one, because she's involved, she was actually on medical leave, and our guidance states that we're really not supposed to be in contact with folks who are on leave. So I abided by that guidance and did not receive any communication from the director at the time. But as stated, I was in touch with the acting director at the time to try and to alert him to the fact that Dr. Bird was implicated, and to try and get more information about this.
And that was it. You ignored the extra 488 miles.
Ignored, as in?
As in not reporting the specific fact that you discovered as part of your investigation an extra 488 miles.
Objection, asked and answered.
Sustained. Sustained.
Why didn't you
Asked and
specifically report that? Why didn't you isolate that and say, there was this trip to Jeff City, but let's look at this 488 miles?
Objection, asked and answered.
That's not the same question.
Like I said, I cannot recall if I brought this specific log up with Ms. Donaldson, but had several meetings with her about this investigation, or this need to obtain more information because of the nature of this trip.
Time check.
I got about 2 minutes left.
Thank you. Dean Dibo, you say he's a friend of yours.
Dean Caperi-Dibo.
Dean Caperi-Dibo.
Correct.
A friend of yours.
Correct.
Y'all go to school together?
No.
Okay. You had, what, 22 calls over the course of 45 days with Dean Perry-Dibo?
I don't know the exact number of calls.
Okay, well, let's take a look at a log that was provided by your good friend, and let's just put that to bed here. Look at Exhibit 6 in our binder.
Which one?
All right, and let's flip into a couple of pages. I just want to get first of all, the first page, 314-749-8612. Whose number is that?
I don't know. I think I live in the cell phone. I live in the cell phone age, so I don't know
Well, pull up your
numbers
cell phone
other
and
than,
see what
sure.
Mr. Dean
Other
Perry-Dibo
than my mom's number and my home number and my wife, I
in the same way.
don't think I know. Let me see.
Object, there's been no foundation laid for this document. We don't know what this is.
Well, I'm not offering the document. I'm asking him a question about his contacts with, what he acknowledged was with the former chair. Is that his number?
It appears to be.
Okay, and your number, just so we keep the record clear on this.
Are you guys going to redact my number, or like, how is this going to,
Well,
from the record?
I'm not gonna speak your number out.
Okay.
I just want you to verify that that's what it is. So if you flip down a few pages, do you see an entry on 10/1/24?
Hold on a second.
You see an entry for 10/1/24? Let me help you out.
Oh, yes,
Is that your phone number?
yes.
Okay. And if the records show that you called him a total of 22 times over the course of 45 days, did you have any reason to doubt that?
Let me just object once again. I mean, what's the basis of that question? There's no, if you're referring to the document.
I'm not referring to the document. I'm asking him if the document shows there was a call number 22 times, whether or not he would dispute that.
And it's hearsay if you're talking about a document that's not in
I'm
evidence.
asking this
All right,
question.
Mr. Harris, your objection is overruled. Do you understand the question, Mr. Boyd?
I don't.
All right, repeat the question.
you
This is the
know-
last question. You
Do
are out of
you-
time once you get this
I appreciate
question
that.
answered.
Thank you, Your Honor. Do you know if over the course of a 45-day period, you called Mr. Dean Perry Dibo 22 times?
I did not count the number of times I called him, and as stated before, sometimes we played phone tag. I know he had a death in the family during this time, was recovering from knee injury. I think around, maybe that was earlier in the year, but maybe I'm confusing dates. But like I said, played phone tag with him several times, and along the way would check in with him on family and how he was doing.
All right, time is up then. All right, that concludes the cross-examination. We'll break for lunch. It's 12 minutes after 12, so we'll break until 20 minutes after 1. All right, come
Yes.
back for a redirect of this witness, Mr. Boyd. Need to be back at 20 minutes after 1. Okay? Sure. All right. And then after that, Mr. Harris, you anticipate some other witnesses after Mr. Boyd or not?
Potentially, but we may be done.
May be done, we'll see. All right.
Well, there are a couple of witnesses, just so we're clear, that he has control over, and I just want to make sure those witnesses that we've subpoenaed are available.
I think one of them we need to, revisit
Talk
our
about
motion
whether-
to quash.
Pardon me?
There's a motion to quash that we filed with respect to one of the witnesses that I think they're intending to call, and so we need to take that up.
You filed a motion to quash? Is this a
Yes.
witness that has a lawyer?
No,
Okay, is that witness gonna be called?
no.
Okay, so that,
No, I plan to call the witness.
that has a lawyer.
That is represented by Mr. Harris.
No,
who
no,
accepted
I'm
the service
talking
of
about the
subpoena.
separate, remember the lawyer that was here asking about?
Got it.
You're not planning to call that witness?
No.
Okay, so we're done with that one. You've got a motion to quash the subpoena
Right,
for that particular witness.
that's correct.
Do we know who it is? Is it in the motion?
It's in the motion. It's, I
Okay.
believe it's the airport director.
Yes.
Is that who it is?
Yes.
All right. Okay, we can take that up after the redirect, I suppose? Is that all right?
Yes.
All right, we'll do that then. Remind me to take that up after the redirect, please. Okay? All right, with that, we broke for lunch, and 14 minutes after, we'll still come back at 20 minutes after 1. We're ready to resume. So where we left off, of course, was the end of cross-examination of the witness. Is there any redirect of the witness?
Yeah, briefly, Your Honor.
All right. Thank you. So go ahead,
So
you may
Mr.
proceed. We are recording, right? We are on the record, yes.
All right, Mr. Boyd, you recall on cross-examination, you were asked to, assume that the trip that the director took was in fact to grab some papers and come back. right?
Yes.
Is that-
Yes.
I think that you were being asked that to get your view on whether or not that would place Mr. Byrd in a precarious position,
Yes.
right? Well, so since we're going to assume, let's assume she indeed went on the trip to see if her husband was cheating and took her subordinate, Dr. Byrd, with her. Assume that scenario. Would that put him in a precarious situation?
Yes.
In fact, I mean, would it be precarious if he's with her while she's violating a city policy?
Yes.
He's her subordinate.
Yes.
You were shown Respondents Exhibit 12, the email from January 2nd regarding the presence of attorneys on city premises, right?
Yes.
And I just want to make sure I understand what that is. So that I think you testified it was communicated to you that employees felt uncomfortable about it.
Yes.
And you're checking into that.
Yes.
Okay. And you were asked questions on cross-examination about the vehicle log, right?
Yes.
And the vehicle log had, it shows, indicates the amount of miles that that vehicle was driven, right?
Yes.
If in fact Dr. Byrd, let's say, had violated the policy even further or continued the violation by driving the car, however many more miles it was, 400 miles, does that negate any violation that the director was involved in?
No.
Okay. So it doesn't mean that she didn't do what she's alleged to have done?
No.
Okay. That's all I have.
Any Reed Cross?
Yes.
Just on those 2 points?
Just on those 2 points. Okay, so now we're clear on the hypotheticals now, right? So let's get back to my hypothetical, which is, let's assume they believe, because they are the fact finders, so they have to decide whether they're gonna buy that version or the truth. So hypothetically, if she is going to retrieve some papers and returning back to St. Louis, how, in your view, does that put him in a precarious situation? If those are the facts.
Because he went to Jefferson City under the pretense of that there would be some business in Jefferson City. There was no business in Jefferson City that related to his duties with the city of St. Louis.
Okay, and there was business, we know that, so they have to decide that issue. But where does precariousness come in? That's what I'm trying to, precarious is a term that you use, so where's the precariousness in that context?
Well, when I said precarious situation, it's based upon what the account of what actually happened, not a hypothetical.
Okay, but what actually happened, according to testimony, is that she went to get the papers. Let's just start from point A to point Z. She went to get some papers, right?
She said that is what she has said was
Right. And
a
you don't
reason.
have anything to the contrary other than speculation about trying to spy on her husband, right?
No, I asked her what papers in efforts to actually learn more about the trip and was not provided with an understanding of the actual papers.
So you're saying when someone signs on to be an employee of the city, they waive all of their rights to their privacy is what your position is?
Objection, mischaracterized as testimony.
I withdraw the
Overruled.
question. No
It's a
further.
question. It's a question.
Okay, let's answer.
Objection's overruled.
No, I don't believe you waive all rights to your privacy.
Okay, so the fact that she wanted to maintain that privacy, you're saying you're using that as a basis to terminate her?
No, I simply was trying to understand the nature of the trip. And I could not understand the nature of the trip based upon the time and desire to get personal papers the day before July 4th without actually understanding what required such urgency.
Okay, and so you're saying, though, she had to disclose to you what the contents of those papers were in order for you to give her a pass?
I simply wanted to understand the context of the trip, which I had a challenge doing.
And you understand that she has a right to privacy, right?
I understand. I understand that she has a right to privacy. I also understand that as an appointing authority, I have a requirement and responsibility to investigate alleged wrongdoing.
And violate her privacy, is what you're saying. That gives you authority to violate her privacy.
I can't answer that question as a clear-cut yes or no. When someone conducts, when someone's private life occurs during city time in a city vehicle with a subordinate, it's difficult to, I guess, argue that it is a private, that private instance doesn't become something relevant to the city based on the time, resources, and involvement of a city employee.
And to be aired out in a public hearing for the world to hear.
As stated before, I wanted to avoid the nature of kind of potential of airing these grievances, or not grievances, I'm sorry, that these allegations in the public, but because it happened, because it involved a city resource with a city subordinate, this is the process that we have.
Right, to violate her privacy and air it out in this public forum and use that as a basis to try to get her to resign, which is what you testified to earlier, right?
Any object, we're, well beyond the scope of the redirect.
Well, this is what he opened up
Asked and answered.
when he said he was trying to protect her from this invasion.
The objection to asked and answered is sustained. Nothing new in that question, Mr. Norwood. You've asked that before.
Fair enough. Thank you.
Okay. All right, no further recross, so that ends this witness. Mr. Boyd, you're excused. Free to go back about your duties. All right. Any other witnesses on behalf of the appointing authority?
No.
Appointing authority rests.
Yes.
All right. We'll be ready to take up defense witnesses then. However, before we do that, as I understand it, there are several motions that might pertain to that. So the first one is a motion filed just last night by the appointing authority, which is sort of questioning the process we went through yesterday evening about scheduling the remaining hearings. And so the commissioners got that emailed motion last night, reviewed it, have asked that I ask, first of all, because it wasn't clear from our memories, the commission is available this Friday to continue this hearing. Are the parties available this Friday?
I am not.
All right.
I have a flight and I will pull out my receipts to a prearranged flight to the ABA mid-year meeting in Phoenix, Arizona. Leaves tomorrow and we get back Sunday in time for my Monday oral argument before the Court of Appeals.
Okay, tomorrow you get back, when? Get back Sunday?
Get back Sunday.
And oral argument in the Court of Appeals Eastern District is Monday, which
Monday
is
morning.
the February the 3rd,
Yes.
right?
Yes.
Okay. All right. So, now, I think the appointing authority in their motion suggested February 3rd. That would be out because of that, correct?
I think we could do the afternoon, and I think we say in our motion, February the 4th and 5th as possibilities as well. And I know we talked about that, but I recall that there was some indication that the director was unavailable, but we don't know the reason why. And I think we need to, considering what we're doing here, I think we need to have some clarity as to, I think first off, we need some effort to have, the hearings for the time that we need. and if not, some evidence of an unavoidable conflict on those dates.
I can do that.
Both commissioners are saying they'd be willing to do it Monday afternoon, Mr. Norwood. What about Monday afternoon?
It's
You're
on
arguing at what time?
10 o'clock. Well, it's on a docket for 10 o'clock.
But that would mean you would be done in the you'd be free in the afternoon?
I need some decompression time, just in case my chi is really high after arguing, but anytime after 2, I could probably make that work.
Well, then 2 o'clock, 2 to 4, is that worth doing?
I mean, I think it's worth doing. I would push.
3 to 5.
I would push 1. I would push 1 o'clock, but I mean,
I just want to be clear, and I understand scheduling is incredibly difficult, but I also want to be clear that I'm taking, and I know we are all taking this very seriously. Your client, as you said, is fighting for her life.
Her reputation,
reputation.
her family,
For her family.
her love,
For her
yeah,
love.
all of that.
All of those good
rolled
things,
up into one
right?
proceeding. Yes.
Absolutely. And I certainly recognize the challenges under which she is.
Yes.
But I also recognize the somewhat privilege that she has in being able to contest this throughout her workday.
Okay.
My workday is on hold right now.
Nothing that we're doing.
Your workday, sir, is being billed by the hour.
Right.
Mine is not.
I understand all of that.
Okay? My university has been gracious to allow and to recognize some of this time as volunteer,
Right.
as civic engagement,
Right.
but I've also gotten to this point and place where I'm beginning to feel uncomfortable with taking such an amount of time. By the end of today, there will be 5 days at nearly 8 hours. Right?
Right.
That's a whole week.
I understand all of that.
Okay? Today and yesterday, I took as vacation day, personal time,
Right.
because I'm starting to feel as if what my university is willing to give me, I'm now taking advantage of. Okay? So what I'm asking, and I appreciate the motion, and I'm actually in support of the motion, that we seriously ask for evidence of tight schedules that are preventing this party from coming at the dates in which we are shifting our vacation, or using vacation, of which we are shifting medical doctor's appointments, so that we can accommodate and to serve our civic responsibilities. I'm hopeful that we will be willing to conclude this as quickly as possible so that we can all get back to the responsibilities, both professionally and personally, that we have.
And in response, we appreciate all of that, right? We have not even presented one witness in this case yet, right? So whatever timeline we're on, we've been at the mercy of the appointing authority, okay? So when we schedule the subsequent hearings after the 7th, we all looked at our calendars and picked dates that worked for everyone, including you all. I didn't know anything about rescheduling appointments and anything. I've got an active practice myself that I put on hold. And I had no idea that we would be here today with this thing. I thought we would move quicker, but we haven't. And I don't necessarily put the fault on Reggie. I don't put the fault on me in the sense that We are just trying to protect her. You get a job to go back to. And if all goes south for her, she's out on the street, along with 4,500 civil servants that you all represent who could be at the mercy of the mayor. And I understand, I recognize the inconvenience. But you're not paying the freight and the bill that she's paying through my firm that I'm getting pressure on right now. So I understand your issues, but we have our issues. And I don't understand why we have to rush to judgment with her life on the line. The rules change in the middle of the game? Okay, fine. The motions, every motion they filed has been heard at this public hearing. Every motion we filed, except one, maybe two, of the 16 motions have been denied. So somewhere I'm seeing an imbalance. I'm seeing unfairness. I'm seeing due process being kicked in the derriere. And I don't like it, and I've never seen it before. And so I'm mindful of schedules, and the fact of the matter is he's the one who's rushing to get this done at my client's expense. And so I haven't put on a witness yet. So to the extent that we're where we are now, and of course in the middle of the thing we've compressed it. So now I'm handcuffed in terms of cross-examining a witness who deserves an hour plus with the evasiveness, and I gotta punch the clock and make sure I get it done. So everybody's inconvenienced in this thing. But it's not about the commission, it's not about them, it's about this woman who the evidence establishes has dedicated her life to the city, who works overtime, who gets up early, who has worked with you all. Despite the fact all of this stuff going on, she met with you all yesterday, courteous, and made sure the city's business gets done. She's the victim here. She has rights. And all I'm asking from this tribunal is, which is what I ask of any client, is fairness.
So it's pretty clear that no one's been, we certainly, nobody can say anybody's been rushing through this hearing process at all. We started on January the 7th. This is January the 28th. It looks like we may be creeping into February. And we have gone sometimes one day in a week, sometimes 2 days in a week with hearings, and then we've skipped entire weeks. So nobody is, hey, maybe it'd be nice if we could rush a little bit, but we've been unsuccessful at that. And the motion that was filed to put time limits on, on witness examination, et cetera, it's clear that that was needed, given especially how this hearing started out with a couple of hours of argument back and forth on issues that were already ruled upon. And, I think that the commission can see that it's clear that we need to move things along, and that skipping entire weeks, without any testimony, without any evidence, without any hearing whatsoever, is a bit ridiculous. And just, having a hearing one day or maybe 2 days in a week is simply ridiculous. And I understand this is a quasi-judicial, tribunal process, but just, if we were in, the traditional court of law with judge, jury, et cetera, the parties could not say to the fact finder, to the court, I'm not available on, that day, so you're going to have to reschedule court that day. No, that wouldn't be tolerated. It seems to me that the commission has bent over backwards, and I applaud you for bent over backwards to accommodate the director in this process. She's not a victim. Her life is not on the line. Now, her current position, her current employment, sure, that's on the line. But the evidence is that's her doing. that's her doing. She's the one who engaged in the conduct that is under review here. And so instead of us skipping whole weeks to have hearings, I think we need to, tighten this up. And that's why we filed and we held off. We had held off a long time to, try and move things along, but we have to do this. We have to ask that let's have court sometimes. Let's have hearings sometimes. A couple days in a week, not skip whole weeks. And I'm not faulting the commission. I'm just saying, under the circumstances, we can't just be saying, I'm not available that day and move on. I think we need to tighten that up.
Mr. Harris, you're not faulting the commission and you're applauding us. You're just saying this is all ridiculous. So I think that you need to decide, which. Now, also, I appreciate your comments about a court of law because I presided in a court of law for 20 years and practiced in a court of law 20 plus years before that. This is not a court of law, number one. But number two, this is an unprecedented process. The city charter lays out the open hearing, and that's all it says really about the hearing. It doesn't lay out any process. The commissioners are not like judges like I was when I was a judge in the 22nd Circuit. Commissioners are not getting paid for their time here. They have other jobs and obligations and things. So working around their schedule is something that has always been done in the past. What is unusual is it is unusual that this hearing is lasting more than one day. But the fact that it says in the rules most hearings should be over in one day, and most are, so what? Your case took way more than one day. Whether you want to talk about Mr. Norwood haranguing or not, or in his words, filibustering, your case still had more witnesses and took more than one day. So we are trying to work with everybody to be fair, to make sure that both sides get their fair hearing to present the evidence that each side feels that they want to present. It's up to the commission to decide whether it's relevant or not, but we're trying to do that and also accommodate you. Now, enough. Where we left off was, I personally have talked to the commissioners. I don't think it's worth it just to come here for 2 hours from 2 o'clock to 4 o'clock or 5 o'clock, even 3 hours on Monday. And that's iffy with Mr. Norwood having his argument, and who knows the cases. When you're on a docket, there can be 3 cases, or it can be, who knows how long, when he'll be picked and so forth. So it'd be iffy that he'd be here on time. And so the next day after that is Tuesday, February 4th. Now, last week, or yesterday when we asked about that, somebody said they could not make it. I believe it was Mr. Norwood. Is that correct, Mr. Norwood?
Yes,
The
my
commissioners
client
would
has
ask.
a medical conflict, yes,
Medical for you or for Ms.
for
Gray?
my client,
For Ms. Gray. She has doctor's appointments?
yes.
All right.
That's what
We
I'm
both
saying,
changed
right?
doctors'
We
appointments.
both have changed our own doctor's
Yeah.
appointments.
Three
My doctor's
times.
appointments, though, are probably a bit different than
A doctor's appointment is a medical appointment nonetheless. Never would I say mine is more important or less so than yours. You don't know what my situation is either.
Well, right, and
So,
the
doctor
doctor's schedule
appointment, that's
dictates
enough.
that.
That's enough to pass Tuesday?
Apparently so.
Satisfactory?
Well, I mean, it isn't for me, I think
You wish
we
to know
could use
more?
Tuesday. I've had to change doctor appointments, this idea you can't.
I'm sorry, just for clarity, mine is not Tuesday, it's Wednesday.
Oh, so
and
Tuesday
Thursday.
does work.
Thursday is where I'm
Okay,
So we
got
could
the
do,
4th.
we could do Tuesday, well, let's,
Can do Tuesday, the 4th?
hold on a second, Tuesday the 4th,
I believe worked for you yesterday was.
yes.
Yes.
All right. So, rather than going to the following week of the 11th, we will schedule the next hearing for Tuesday, the 4th at 10 o'clock.
Yeah, that's
To
fine.
the, at 10 o'clock? All right. Now, you've already said the next 2 days, Ms. Gray does have doctor's appointments or something? So what about Friday, the 7th? Did we talk about that?
Well, can we back up for Wednesday? I mean, is that?
Wednesday
is
and
that a-
Thursday, the
all-
5th and 6th?
Are those all day?
Well, okay,
Appointments, I mean-
I'm asking to,
Yes, they are.
I will shift some of mine.
I'm sorry,
I said I can shift something for the afternoon.
your appointment,
Yes,
but you would only be available in the afternoon?
the other way.
Only be
I
available
need to
in-
wrap
in-
by 3 o'clock on the 5th,
So you would be available from, all morning
until the 5th.
until 3
Until-
o'clock?
Yes, until
And-
3 o'clock on the 5th.
And I'm
You'd be
fine.
available that time in the morning until 3. Ms. Gray, you heard the commissioners would be available from the morning till 3 o'clock. Would you be available until 3 o'clock?
I won't be available at all those 2 days.
Not at all,
Not at
either
all.
one of those 2 days because of medical
Yes,
appointments?
yes.
And I'm not available Wednesday, the 5th, starting at 2 o'clock.
Starting at 2.
I mean, for fear of, of being viewed as some sort of a bad guy, I would ask for proof that these all-day appointments on Wednesday and Thursday are in fact all-day appointments.
All right, both commissioners want to hear from Ms. Gray why it has to be all day both days.
Should I come up to the podium?
Well, just to clarify, as it relates to Tuesday, 2 o'clock and after, I have a commitment. I'm sorry, on Wednesday, 2 o'clock and after, I have a commitment.
Wednesday's the 5th, right?
That is the 5th, yes.
And your commitment starts at 2?
Yes.
At 2 o'clock.
2 p.m.
All right.
Federal Practice Committee meeting, Judge Clark, so we can call him and verify the fact that we have this initial meeting of the Federal Practice Committee.
All right, that's at 2 o'clock. But Ms. Gray is saying she would not be available all day that day,
The 5th and the 6th,
5th and 6th.
yes.
All right. Go ahead, Ms. Gray.
Without getting into my specific medical issues that are existing, there are some things, there are some treatments that I need to undergo that's going to keep me not here at work or being able to do anything. And I really don't want to have to go into the details about what that is.
That's sufficient.
Yeah, I guess so.
What about Friday, the 7th?
On Friday, the 7th, I'll be in Columbia, Missouri, teaching a pretrial practice course from 2 o'clock until 3:40. And typically, rather than driving up the morning of, I go up the night before.
Is there a way for you, I've been a professor as well, and I understand that there are opportunities, it should not be a standard practice, but I am well aware that there are opportunities in which guest lecturers can come in, you can provide additional assignments for your students in lieu of said class time, so that we could convene here on that time.
Well, I've made a commitment to the University of Missouri, my alma mater, and I've made a commitment to my students to teach 1 day a week. And this is the 1 day a week that I've carved out to teach those students. And so I don't want to cheat them. The ABA has certain requirements for 2 credit hour courses. And there's nobody I can pawn it off to.
I didn't say pawn. I
Well,
said you
I'm sorry.
provide
That's not your
a
term.
guest lecturer who
I don't have any guest
high-quality
lecturers.
standards
I don't know. Do
in
you want to go
Columbia,
down
Missouri,
and
at the
guest
law
lecture
school, at the
pretrial
law
practice
school.
for me?
I don't imagine.
At the law school. There should probably be some folks of comparable.
Well, I don't know.
Standards of yours.
I'm not on campus, so I don't know.
You willing to accept that?
All right, both commissioners, Mr. Norwood, feel that you need to make arrangements to somehow,
I
Either
can't make
alter that
arrangements,
or- well, they-
Your Honor. I cannot make arrangements when I've committed to the University of Missouri. Okay? I can't make arrangements. There is nobody to step in. I'm stepping in.
Mr.
This-
Norwood,
This is,
what would happen if
We
you had a
did-
trial that week and your trial was still going?
I planned my year in advance. I made this commitment way back in the summer. I taught last semester every Friday. I'm teaching this semester every Friday.
Well, I'm afraid, both commissioners are telling me they're denying your request.
Well,
To
then
continue the
we
case
have an
past
issue.
the
We
7th.
have an issue. This is unfair to my client. It's unfair to these students. It's unfair. It's not like we had a docket, a prearranged docket like we had before Your Honor, where you said, this is the week we're going to trial, right? This is sort of hit or miss. And according to the rules, we would confer and work through scheduling. This is how we operated. So I am operating under the assumption that we're going to work around schedules, like we're working around his schedule and your schedules. And for you to arbitrarily, the commission arbitrarily say, drop your students,
Sir, I've been
No,
asked
no.
to drop my schedule.
well, I shouldn't have to drop my schedule.
Neither should I, but that's
When-
what we're forced
when
to do. That is what we're forced
This
to
wasn't
do.
on the schedule.
You absolutely are correct. But nonetheless, I'm making accommodations.
And I'm willing to make accommodations.
We
But
look
I don't
forward
wanna-
to seeing you on the 7th.
I don't want to, that's unfair. And everybody in here knows it.
Well, fortunately for us, this is about your client,
no,
the
no,
city.
no, this is-
us
this
and
is-
and the public are hearing this, and that's what we've
They're
asked them to
hearing
we've been
me
charged to
plead
give
with
them.
this tribunal not to punish the university, not to punish university students, to accommodate.
Are we talking about
this
Webster
tribunal.
University students?
I'm talking about University of Missouri in Columbia, Missouri.
And I'm just letting you know, frame of reference, I'm at a university as well.
And my wife's at a university. She's done it for 33 years. Okay? So, how we doing?
I'm just letting you know that I'm looking forward to seeing you on the 7th.
Well,
as
and
I
I'm looking
make
forward, if I have to
accommodations.
go across the hall and get a writ, I'll get it. This is ridiculous.
Well, of course, Mr. Norwood, that is your right to apply for one. All right?
Fair enough.
The commissioners have both reiterated to me that they are denying your request. All right?
Right.
So I'm not misstating that, am I? So I'm here at the.
Very clear.
I'm here, the commissioners are running the show. I'm here at their direction, all right? So
So what time are we on the 7th?
so the 7th, and that was the only thing was that you were gonna be gone all that day, so we'll schedule it for 10 o'clock and go all day for the 7th. All right? 10 o'clock to 5 o'clock if necessary. All right, and Mr. Norwood, if you do not successfully get a writ, perhaps an associate in your firm, right, could handle it for you,
Handle what?
the hearing. If you,
Well,
if
I
you would
am
choose,
not-
if you would choose, obviously that's
I
your
am not the
choice.
kind of lawyer to leave my client in a lurch because of some arbitrary scheduling.
Well,
That's not how I roll. And I
Maybe-
haven't rolled that way for 36 years. I give you and have given you the ultimate respect as you has given me in a court of law. But this ain't a court of law, and this is as kangarooish as I've ever seen in my life.
All right, well, with that, we know what
So
we've
we
scheduled.
repeat the
What?
10th.
I'm sorry?
So we just continue on through calendars for the 10th.
Well,
week of the 10th.
we had, the 10th was, the next day that we had talked about was Monday, the 10th last week,
We
yesterday.
talked about the 11th last week.
11.
Well, we set it for the 11th. Is
Right.
anybody asking that it be set on Monday, the 10th?
I'm not opposed to it. My calendar is open for the 10th.
You want to do the 10th. Anybody not available on the 10th? I can't remember what anybody said yesterday, I'm sorry.
Well, here is what I would propose, because, I mean, and really,
Go ahead.
maybe the way to do this, because we need to figure out who we're gonna be able to call, because that's gonna dictate how many days we're gonna need. And depending on the rulings, we may only need another day or two. And if that's the case, then I would beg for the accommodation for Friday, and we finish up on the 10th and 11th and be done, right? And nobody's inconvenienced there, if that's the case. But maybe we should then rule on who we're gonna be able to call, and then we can figure out how long my case is gonna be, since we know how much time we have. How about we try that?
All right, well,
For the record, I think that sounds reasonable. I appreciate the efforts.
all right, but, right now, then you're saying defer any further discussion of scheduling until the motion? Is that what you're saying?
Yes, I think what Mr. Norwood was saying was, you know, we're gonna have to have a discussion and an argument about which witnesses that they would like to call, that we have, some of which we have objected to, and so that might.
Well, that's your motion to quash subpoenas as issued to certain people, right?
Correct.
All right, so let's take that up, I suppose. That would be the next thing. The appointing authority's motion to quash subpoenas directed at certain witnesses, starting with Mayor Tessara Jones. So, and we deal with this one at a time, each different witness, all right?
Okay.
I mean, I assume there may be some differences, I don't know. That may be the easy way to do it, I'm just guessing.
Right, it's our understanding that, the director, intends to call the mayor, Mayor Jones, to testify. We filed a motion to quash, that subpoena and to not allow that, testimony, for various reasons, including the fact that, you know, under the law, under both federal and, state law in Missouri and other places, you know, calling, you know, high-level executive authorities to come and testify, is often disallowed when, because it pulls them from their regular duties and can be disruptive, particularly when there are subordinates, you know, whom they supervise and whatnot, who could provide whatever, you know, evidence that is sought, that would be sought from the mayor. And so I think calling, you know, her, who's clearly a high-ranking official, executive official, you know, should not be allowed in this case. I think also there's been testimony that it's clear that she was not involved in this matter, has no personal knowledge. I think the director herself testified that she never spoke with the mayor at all regarding this matter, and so she would have no personal knowledge with respect to the underlying conduct that is at issue. And so for those reasons, I think that the subpoena to have her come and testify should be quashed.
All right, Mr. Norwood, regarding the mayor?
The mayor is a critical player. Our theory is that this is political interference. It's a hostile takeover of the civil service system. We have evidence from my client of those efforts by her underlings. No one is coming here and testified that she hasn't been involved in orchestrating that interference. Nobody has testified that she didn't make the final call as to whether that letter went out. No one has come in here and testified and denied the little piece of clip we were able to show where she went on public record to say, I'm taking over the civil service department, the directorship, and the whole nine. That is evidence that she can opine to. She can deny it, she can say what she wants to. But the charter and every constitution I'm aware of that still exists allows us to present our defense. She is a key player in this whole thing. And so to the extent that it's been suggested that, well, she's a high-level figure, she's testified in other cases. He knows it, we know it, because if she's a player, then that means she has to play. And so she can't divorce herself from this process by sending in some of her underlings to do her dirty work, which is what we're suggesting is happening in this case, right? And so we have her, we have a limit. We can do it during her lunch break. But she is a critical witness to this whole thing, and we have every right to call her to testify and explain why, in the history of this charter, no one has ever attempted to remove a director of personnel. Why no one has ever been disciplined for a violation of the very policy that they claim is being violated. So all of that is germane to the very issue. She, in fact, on a video, in response to Elliot Davis, couched the issue in these terms as she was avoiding these questions, probing questions by the media, that in terms of her personal vehicle usage, it's a question of taxation. That for the personal use, I pay taxes on it, and that's all that matters. And that's what she said in the video. And so to that extent, we're entitled to put her on the stand. And to the extent that there's a suggestion that for whatever reason, under the due processes, the Alice and somebody else's Wonderland determination that somehow she shouldn't have to testify, then we should be allowed to put her on with respect to an offer of proof, make our record, and let some other court decide whether or not it was improper to exclude her when she's a critical player on a critical defense as outlined by the charter.
Well, Mr. Norwood, I believe, first of all, I did not catch as you were talking, so please just tell me, I didn't hear the last part. You said no one has testified that the mayor did not make the final call to do what?
As to issuance of the termination notice, as to going forward with this process, despite the fact that nobody's been disciplined, there is no witness who has testified to that effect.
Right. All right. I thank you. Like I say, I just didn't hear what you said in that part of it. Mr. Harris?
I mean, just because someone gets up and makes some specious, conclusory allegation that the mayor must have been involved, does not mean you then get to call the mayor to the stand and explore whether or not your conjecture is correct. If the director wants to ask someone whether or not the mayor made the final call, he had Mr. Boyd on the stand, and he could have asked Mr. Boyd that. And I think Mr. Boyd testified to, he was delegated the appointing authority according to those documents, and he's the one who wrote the letter and made the call in terms of submitting a pre-termination letter and starting up this process. I mean, the cases talk about how, when just because a plaintiff or just because, a party gets up and says the mayor must have been involved in some way, I mean, that does not then give you the ability to just call the mayor and other similar type witnesses to the stand and examine them.
All right, the motion.
Well, let me before you
Go
do
ahead.
that. This delegation is an issue, as we learned today. The delegation of authority didn't happen until the day of the letter. So really, in our view of the world, that whole investigation was improper. We need to figure out, why did she wait until the day of to appoint them and provide that authority? Number one, we also take issue with the ability of her to delegate that authority. There's some cases floating around out there, and we could submit them to the court, where the whole delegation may be improper. But all of that requires us to examine this witness, this delegee or delegator, with respect to that issue amongst the many others that the charter said. Now, the charter is clear. Political interference is illegal and improper. To the extent that we're able to establish through examination of her that there was political interference by her.
What section of the charter are you citing?
Section 16 of the charter.
Section 16 of the city charter. And you're saying that says what?
It prohibits discrimination based on race, sex, political opinions. That's expressly set forth in the charter itself.
All right, the motion to quash the subpoena of the mayor is sustained. All right, next person on the motion.
Excuse me, what about my offer of proof?
We're gonna have to we'll talk about that, but let's talk about that after we go through this motion, all right? Quash subpoena of mayor is sustained. Next person on the motion.
For similar reasons, I think the director is looking to call Rhonda Ham, I'm gonna mess up her name, Ham Nybrugi?
Starts with an N. Okay.
Yeah.
The
who is
airport director.
Director of the airport. So for similar reasons, that she's a high-ranking official, I don't think that there's any reason for her to come in and testify. But in addition, throughout the course of this matter, I don't think her name has even ever come up in evidence. I'm at a loss to understand why her testimony would be relevant in any way. She also has no personal knowledge as to the underlying conduct in this matter. I don't believe she's spoken with the director about what the director is alleged to have done, so I don't see how her testimony comes in at all.
All right, Ms. Norwood.
She has direct testimony about political interference by the mayor as it relates to the reemployment rights of Mr. Richard Frank, who was the former personnel director. We've had testimony today, skewed as it was, with respect to Ms. Baker talking about how they were trying to ship him out to the airport and looking for an opportunity in the goodness of their heart, which is false, and we're entitled to improve that. She's going to testify. Our understanding is she's going to testify that she was approached by Sheena Hamilton, by Sarah Baker, one or both, with respect to making a spot available for Richard Frank to clear the debt so that when they remove her, which is what they're trying to do today, she could slip in her own provisional appointee. And that's interference, that's a violation, and that's what she would testify to.
Again, I think that as to the underlying conduct that's at issue, she has no information. And this notion of political interference, as we've argued in other motions, that is irrelevant. And the notion of political interference, or however it's phrased in the charter, again, has to do with, for instance, one political party coming into office and then firing the opposing political party just on the basis of the fact that they are an opposing political party. Not, some issue where there's discussions around the policies of, whoever is in office and disagreements and things of that nature. Whether or not someone was, terminated for some ulterior motive, in addition to the fact that the employee violated policy and did in fact engage in the conduct that warrants termination, that this other alleged ulterior motive about which there is scant evidence is irrelevant.
That really is overlapping with your other motion about political interference, is it not?
Yes.
All right. I believe, Mr. Norwood, you'd have to be in a position of making an offer of proof. All right.
I'm sorry?
For now, on Ms. Ham-Nieberger, as in addition to the mayor, the motion to quash the subpoena of the airport director at this time, well, I'll tell you what, we'll hold off on it until we hear the motion on political interference.
Well, I don't know what motion on political interference is.
They filed a separate motion.
And I don't, what's that one saying?
That was the motion to eliminate we filed from a few weeks ago.
Now.
Well, okay, so their view of the world is that we can't, that this
Well,
commission,
are you want to argue that motion now?
it may as
the
well,
political
because some of these
interference
other
one?
witnesses relate to the same issue.
Might as well, I think.
May as
It's,
well.
Because, as I understand, Mr. Norwood's answers to all of these relate to his defense of political interference, all right? So, with that, then why don't we just move for a moment to your motion in limine to prohibit testimony about political interference, I think is the way you worded it, something like that?
Your Honor, if I
Yes.
may, the motion is in the front pocket there.
In the front pocket
the
of
motion.
your motions, right here, yes. Okay, great.
Yeah, so this is a motion in limine to
This one for
exclude,
you.
I'm sorry.
Okay, you have one?
Oh, mine's buried in there somewhere.
Okay, all right. Go ahead, then, we have it.
Yeah, this was a motion we filed to exclude evidence relating to political motivation or uneven enforcement of the vehicle policy. You know, and it basically is that we don't believe that the director can use allegations of political interference or animosity and the like, and selective enforcement of a vehicle policy to distract from the only issue before the commission, because that evidence is not relevant. You know, we've cited a couple of cases. One in particular is the Rorda versus City of Arnold case from 2004. It's 142 Southwest 3rd, 786. And in that case, the plaintiff, it was a former police officer who was suing the police department, who was suing the city because he was terminated for misconduct. And he attempted to put on evidence that, you know, that the chief of police had it in for him, and that there were other folks who committed the same conduct that he did and were not disciplined and were not terminated. The reviewing agency did not allow that evidence because they said it was irrelevant, because if there's evidence that he in fact engaged in the conduct for which he was being disciplined, that was sufficient, regardless whether the chief of police didn't like him or not. And that went up on appeal, and the court said that's correct. That's just fine. That evidence is not allowed in that case because the issue before that board was whether or not the officer engaged in the conduct that violated the policy and for which he could be terminated. So it didn't matter whether or not the chief of police who wanted him terminated didn't like him for whatever reason he had. And so I think the exact same reasoning applies here. The issue in the case is whether or not the director engaged in the conduct that she is alleged to have engaged in, regardless of whether or not she believes that, you know, some political persons, that the mayor is like out to get her or something.
All right, Mr. Norwood?
Well, again, this is his view of the world, and that case has nothing to do with the charter that we're talking about. The charter that we're talking about makes clear that to the extent we can prove, and we're allowed to present evidence, which is where we're here now to present our evidence and present our defense, it says that if there's political motivation behind it, we got evidence of the fact that we had it this morning. She's going on record as saying, I want to bring the director of personnel and those individuals within the confines of the mayor's office. That's in the record. She testified about political interference, right? That all came in. That evidence is relevant to the determination of what this thing is all about. The question of the matter is, there's no dispute that there was a violation of a policy she was unaware of. But that's not the question on the table. The question on the table is whether or not, number one, that rises to the level of malfeasance, and number two, whether or not in defense of that, they're taking a rule that nobody's ever been disciplined for and using that as a pretext to discriminate against her based upon her expression of the need to protect the integrity of this civil service system and continue to maintain it as a merit-based system. These witnesses that they're trying to prevent us prevents you all from hearing are the very witnesses that will provide that evidence. And so effectively what he's saying is that we can't introduce any evidence of interference. That's what he's saying. That we can't, as the charter provides, present that defense, even though the charter provides us the opportunity to provide that defense, even though the due process provisions suggest that we have a right to present that defense, even though that notice, as bogus as it was, told her that at this hearing, she would have the right to present that defense, and now we're being cut off at the knees. These are critical witnesses on political interference. We don't have a confession, but we have something pretty close. In that little clip we were able to show where she made it clear that that's what she wants to do. There's other evidence. When she took over and the director of personnel left, she changed all the locks. She literally hijacked the Department of Personnel. She interfered with Rick Frank because she knows it's sort of the devil you know and the devil you don't. She doesn't want Rick Frank back in the building, okay? And that's why they're inquiring about, well, what about that reappointment letter by Mr. Frank? Because they're playing three-dimensional chess. Get rid of her, block Frank, and here we go. I can plant my own person, and in the meantime, I can continue to push forward to change the charter in a way that's going to deprive civil servants of the independent merit-based system that we've had for over 80-plus years. So to the extent that you're saying we can't present the evidence, that's fine. We'll be back here in 2026 reconvening because I'm going down the hall because this is unfair. It's a violation of the charter to the extent that we can't present the defense that we're entitled to present.
That little clip, as he put it, is not in evidence. That was he tried that during an offer of proof and was unsuccessful, so it's not in evidence. But more importantly, this idea of political interference does not mean what he said he's suggesting that it means. And it only comes into play if the director is, in fact, terminated, at which point, and in this case, she has not been terminated. This is a proceeding for the commission to make a recommendation in that regard. And even then, if she wants to pursue this, flimsy claim of political interference, they can do what he's suggesting. You go down the hall to circuit court and try and argue that she has been terminated, that is, if she gets terminated, for political interference, instead of because she exercised terrible judgment and violated the city policy in the way that she did.
All right. Are you saying, Mr. Harris, that even if there were evidence of that the firing termination was done because of the director's political views, and that the cite to the vehicle policy is only a pretext for doing that? Are you saying that even if that were the case, the commission does not have jurisdiction to consider that?
So, I'm saying that, first off, she hasn't been terminated. Second,
I understand that.
Yeah, right.
That's in effect saying she hasn't exhausted her remedy yet.
Second,
right? She has to wait till she is terminated, right?
Right, and second, I'm saying that, under these cases that I cited,
Let me just ask you, Roeder did not involve an allegation of political interference, did it?
Roeder involved an allegation that the chief of police
Had it out to get him.
Had it in for him, right?
Not because of his political views.
I think that the director here is arguing that the mayor had it in for her.
For political views.
Not,
That's Mr. Norwood's argument.
But what does that? What does that even mean? Political views. So
Mr. Norwood just told you what his argument is. That it is because the director said she was opposed to changing the charter, doing away with certain civil service protections. And she's saying that the mayor disagrees with that. That's his argument. all
Right.
right? All I'm asking you is, are you saying that even if that's the case, that's irrelevant, this commission cannot consider that?
I'm saying that, first off, that is not a political view. Second, even if,
What kind of view is it?
What?
What kind of view is it?
What
You're defining political in a certain way, right? Narrowly?
I suggested earlier
Democrat versus Republican is
right,
political.
you come in and you sweep out folks on political grounds. I mean, perhaps what we need to do is, I mean, if the commission is considering,
I'm asking the question.
Yes.
It's the commissioners who's going to decide this.
if the commission is considering this, as a possibility, then maybe the commission needs some briefing as to whether or not this political language that's in the charter means what he's suggesting it means. I don't think that's the case. But be that as it may, put that aside. If the evidence, and this is what Rohrer shows, if there is overwhelming evidence that the person engaged in the conduct for which they were, disciplined, terminated, then it doesn't matter if the person who terminated them didn't like them for other reasons. And here, the evidence is pretty strong that she engaged in that. She admitted at least violating the policy. And so, I mean, just to come in and say, well, that's not really why. It was really because she disagreed with the director's policy position, without any evidence to support that. That's where the courts don't allow that evidence to come in.
Well, just briefly respond. How else do you prove political interference without witnesses, right? Political interference is in the eye of the beholder. Political interference would be the eye on the commission. They can look at the evidence and say, oh, that's not political interference, and they're entitled to that. The question on the table today is, do we present the evidence of political interference for them to consider and reject if that's the case, if it doesn't rise to the level of political interference? He's trying to read that language out of the charter, essentially. How else do you prove, unless somebody here comes in here and confesses, yeah, I intended to politically interfere? It's just like any other discrimination case, right? Race, sex. Nobody's coming in saying I'm a racist. Nobody comes in, I'm saying I'm a sexist. You have circumstantial evidence of the actions, right? And the pretextual nature of this is borne out by the fact that they ignore all this other evidence of violations. They don't care about the policy. They see 488 miles, double what it took to drive into Jeff City. They ignore all of that. They write an appointment the same day as the letter. All of this is circumstantial evidence of what the true intention was. And then when you layer that on the top of trying to block Mr. Frank from coming back, and these other efforts to put into place provisional appointees as an end run around the merit-based system where individuals on merit, they're in line, they're on a list, and they do an end run around that in order to place their own political appointees. That's all the mayor. That's what she has done. That's what she has been doing from day one. And we have the evidence of that. All we need to do is put her in a chair and let's hear the evidence. And if the commission rejects that and says Norwood's all wet, so be it. But why should we go through this process? Waste all of this valuable time, go up on appeal and say, well, Ronnie was a little right, so now we got to do it again. That's a waste. I don't want to be there. I mean, I may be retired in 2 years, I don't know. But I don't think any of us want to have to go through this again. Hopefully this is a once-in-a-lifetime thing where it's only been once in a lifetime, or multiple lifetimes, because it's never been done before. So from a matter of practicality, let's hear the evidence. That's what this tribunal is about, hearing evidence. And he's saying, you only hear the evidence we want you to hear under the interpretation of the charter we want you to read, so we can get rid of the person speedily that we want to get rid of. And that's not right. Nobody would ever be able to present it. Under his interpretation, no one would ever be able to have that charter provision enforced regarding political interference. And the reason this one is even more significant is because this interference is at the highest levels of government. The mayor and the chief of staff and the deputy chief of staff. How else do you get there? How else do you tell truth to power unless you get these people under oath? There's no other way to do it. So rather than wasting time, meaning having a do-over, we could be wrong, we could be right. As Your Honor knows, we don't know what the higher courts will do, but usually they have a record so they can make a clear evaluation, and all we're saying is let us make that record based on evidence we already have in this record.
Mr. Harris, did you have something you wanted to add?
Yeah, I mean, there is no evidence of whatever this political interference, whatever that even is, and I would urge that the commission, discuss whether we want to go down this road and start putting in all kinds of folks to have them run down this rabbit hole and search for. Because that's what they want to do. They want to search for evidence to support their flimsy allegation that this is a political case, when the evidence is sitting in front of the commission through what you've heard from the witnesses and the documents. So before, if you're even considering this political, whatever this is, argument in theory, and putting these executives, the mayor, the airport director, the comptroller, and all these folks on the stand, when you have before you clear evidence that the director violated this policy, was not forthcoming about it, was not accountable, put subordinates in these uncomfortable situations, that's the waste of time. If they want to try this nonsense in front of the circuit court, let them do that. They can try to do that, but I don't think they'll be successful.
All right, let me ask Mr. Norwood, with regard to the other witnesses that Mr. Harris's motion addresses, the motion to quash subpoenas, are all of those witnesses whose purpose in being called to testify would be for this political interference argument, or any of them for some other reason?
Well, as I mentioned with Mayor Jones, in addition to political interference, this improper delegation of authority issue on the delegation of
Well, I'm
authority.
not asking anything you've already said.
Okay,
I'm just
all right.
saying, for anybody that you haven't addressed yet.
Sheena Hamilton has a bearing on the political interference issue. She has a
But
bearing.
I'm asking, any of these witnesses have any bearing on anything else besides?
Yes, Sheena Hamilton.
On
Darlene
something
Green.
besides political interference?
Gina Hamilton, Darlene Green.
Okay, so let's leave the political interference argument aside for a moment. Let's deal with each of them. Darlene Green, what is your argument? Well, at first, Mr. Harris, do you have anything to add about, obviously she's also a high public official, so everything you said about the mayor would also apply to her. Is there anything you want to add about Ms. Green?
I guess I need to understand what's the purpose for calling her beyond this alleged political interference stuff. I assume it may have something to do with the reimbursement, and if that's the case, we can stipulate that the director paid this $170.30 to the comptroller's office, and so that would take care of that, I assume, unless there's more.
All right, Mr. Norwood, you heard first Mr. Harris's offer that they're willing to stipulate so that if Ms. Green would need to be asked about this money, that they're willing to stipulate that the director, Ms. Gray, did pay back the $170. So, first of all, you willing to accept that stipulation?
Well, it's not in dispute.
All right.
The money's been paid.
All right,
But That's
Is there
not-
anything else that Ms. Green
Yes,
would be asked about
absolutely.
that is not about political interference?
Absolutely. As the longest-serving public official in this venue, as she communicated to my client, no one has ever been disciplined for violation of the vehicle use policy. And she's going to testify to that. Okay. She's also going to testify about instances where individuals routinely are violating this policy, publicly reported, and they still don't get disciplined. So now, in the 80-plus years of the charter, we have a situation where a rule violation, and he read some stuff from the Code of Conduct about violation of regulation. This is not a regulation. This is an unenforced rule. And that the protocol, which is what she communicated to my client, is the protocol she followed. She walked in there, she didn't have cash, but she had a cashier's check for that amount, and she paid the money as instructed by the comptroller. The comptroller would also testify about the fact that there are two tracks in terms of how this should have been handled. And our position is that one of those tracks is the whistleblower track, all of which, and we've got testimony about that that's come in through Dr. Bird, that track is the track that should have been followed. She's going to come in and explain how that process works in terms of when it involves city vehicles, which is all within the rubric of the comptroller, is handled. This is how she handled it. And she would testify to that, consistent with what she communicated to my client. And that's separate and apart from the political interference issue.
So this business about there never in the history of the city being someone disciplined or fired for violating the city vehicle policy, that is the Rorta case that I cited. You know, the same argument was no one ever got fired for doing what I did. That doesn't mean you can't get fired. You know, so that you know, evidence is not helpful and does not have to come in. And I mean, we've been here, and he's asked witnesses, "Hey, have you ever seen, you know, someone get disciplined for this?" And witnesses have said, "No, I've never seen it. I've never seen it." So, in that regard, it's extremely repetitive as well. So, you know, I just don't see where the comptroller's testimony is necessary here.
What we haven't had is the appointing authority, the elected official, who's responsible for the vehicles, who regulates the use of those vehicles. That's all within her bailiwick. And as the longest serving elected official in this venue, she would know about all of the instances, the publicly reported instances, including Elliot Davis camping out in the mayor's office when she was treasurer about this issue of personal vehicle use of city vehicles. She would know that as the longest serving official. So this is right in her wheelhouse. The witnesses we had on stand today, oh, I wouldn't know. That's Sarah. I wouldn't know. You know. And then we had Mr. Understock. Well, I don't know. You know, everybody's dodging and ducking and weaving. She is the person.
I'll just point to, attached to one of our motions was an affidavit from the comptroller. I mean, she said the comptroller's office does not house or serve as the custodian of records for documents related to employee discipline for employees who are not employed in the comptroller's office, or investigations related to personal use of city vehicles generally. The comptroller's office did not perform an investigation into Director Sonia Jenkins Gray's personal use of a city vehicle on or about July 3rd, 2024, or any purported use of any city vehicle by Mayor Tashara Jones at any time. I mean, I don't know what we're doing here.
All right. What about the next witness on the list? Nancy Cross, Director of Operations.
I don't know if, is that
Well, it's
more
your
than-
motion to quash.
I didn't know if that was more than political interference.
Well, is that, in other words, you've made your arguments about the others. Now, she is not a high elected official, so she's in a different category
Well,
a
to
little
short circuit
bit.
that, we don't plan to call Nancy Cross.
You don't plan to call her,
I
so
don't
that
plan to
takes
call
care
her.
of that.
No.
All right? Right?
Yes.
Okay, so How about, you do plan to call, if you're allowed, Sheena Hamilton?
Yes.
All right, and your argument, Mr. Harris, anything different from what you've already said about the others?
Well, it also that I, to the extent that that he wants to get into, communications that are protected by the attorney-client privilege. We think that should not be allowed. Any work product that is any evidence related to the thoughts and the opinions of the attorney for the city. That is not something that is discoverable or even allowed in evidence, of course, because that would run counter to the work product protection. The city councilor was not personally involved in the matter, in that she did not speak with the director about the underlying conduct at issue here. And so for some of the reasons I've already stated and these additional reasons, it would be improper to allow the attorney for the city to testify.
All right, Mr. Norwood, why?
Well, let me count the ways. Number one, as my client testified to, Sheena Hamilton pulled her to the side and said, you better watch out, because the mayor believes that you're trying to sabotage her political campaign with respect to how you're conducting hiring, right? That's what she testified to. That's in the record under oath with no objection by counsel. So she's a key witness on that point, number one. Number two, Dr. Byrd, as well as at least at some point during Ms. Baker's testimony, they testified that Sheena Hamilton, as city councilor, as they've argued she has the obligation to do, was involved in this investigation from the get-go. Yet, Mr. Garvin here, who goes back and reports to his boss on a regular, if he's doing his job, is essentially working with her, who's working with them, to terminate my client. We're allowed to get evidence about that. We raise conflict of issues up the wazoo. How does that work? How does he get to go and meet with Sheena, who was investigating with the investigators, and then whisper in your ear about what the law is with respect to malfeasance? What kind of triangulation is that? That's where we are. How can we trust a process like that? Has nothing to do with you all, because he's your lawyer now, and he's their lawyer now. That's evidence.
You said that part of your argument was that Sheena Hamilton, the city councilor, was involved in the termination process? How was she involved in
She
the
investigated,
termination process?
according to Dr. Byrd's testimony that we heard yesterday. She reached out to him as part of this investigation. Ms. Baker testified that when she got that whistle blow from Bianca, she then reached out to Jared, Mr. Boyd, and reached out to Sheena Hamilton.
I'm sorry, I thought you were talking about Ms. Hamilton. Who reached out to whom?
According to the testimony, yesterday's testimony, Dr. Byrd testified unequivocally that Sheena Hamilton, as the city councilor, reached out to him in conjunction with this investigation. Sarah Baker testified today.
When you say in conjunction with?
Yes.
What was the testimony? What was it about?
He said that he was trying to interview him in conjunction with this investigation.
Who
Sheena
said
Hamilton.
He was trying to interview who?
Dr. Byrd testified that Sheena Hamilton attempted to investigate this matter along with the investigators by wanting to interview him in conjunction with this investigation. That's what he testified. Sarah Baker testified that she called Sheena Hamilton first off to facilitate this investigation, get advice on the investigation. And now, so they're getting advised by the city council's office with respect to the investigation that we're here today on, and the only person in this room who's in the room with you all is the lawyer who works for the very investigator that worked with the investigators.
All right. Before you get to Mr. Garvin, Dr. Byrd said that Sheena Hamilton attempted to interview him.
Yes.
Did he actually testify that she did interview him?
No. Because he avoided it. And we believe that if she's allowed to testify, there are other individuals that she talked to incident to this investigation.
I mean, so the.
Oh, Mr. Harris.
Sorry.
So you believe if you had her on the stand, you could ask her and that she'd say she interviewed other people?
Yes, if she's telling the truth.
All right, the other witness you have on, did you want to add anything, Mr. Harris?
Yeah, I mean, so we're saying, I guess the argument is if someone reaches out to their lawyer, Sheena Hamilton is the lawyer for the city, and representatives of the city, you know, if they reach out to her, then in the proceeding, she can then be called to testify in court about the matter. I mean, that's not how this works. That doesn't work in any other situation. You can't say to someone, you called your lawyer and they advised you. We get to talk to the lawyer. I mean, because if that's the case, you extend that to its logical conclusion, that means I can testify. That means Mr. Norwood can testify. And I don't think that's what this is how this is supposed to be.
I'd gladly testify, for the record.
And also,
Pardon me, Mr. Norwood.
and
Sure you would.
And I think the issue related to Garvin had already been ruled on. I mean, there was a motion to disqualify Garvin, and that was ruled on very early in the matter.
We did.
Okay.
And as to all of these witnesses, if the view is that we can't call them as part of the case, we'd like to make offers of proof and put it in the record and see what
Okay.
we see at some point.
Okay, there's only one more on the motion to subpoena, to quash the subpoenas, and that's Deputy Comptroller Jason Fletcher. Mr. Harris, anything to add with regard to why Mr. Fletcher's subpoena should be dismissed? And no
We-
for
we
you,
don't-
Mr.
we don't-
Norwood?
we don't
any-
plan to
why-
call Mr. Fletcher.
You do not plan on calling, so Mr. Fletcher is off the list. Okay. Mr. Harris, you mentioned two things. One, you mentioned you urged the commissioners to discuss this and kind of near that when you were saying that. You also said something about briefing it. Now, what are you suggesting? I wasn't quite clear what you were saying there.
Yeah, I guess it was this issue of if there is some confusion or unclarity or whatever about what the charter means when it uses the language related to political, influence or interference or however it's put. I mean, I don't know if the commission wants, some legal briefing on that because just because, they're saying that it's political interference under the charter does not make it so. I mean, I think John Understall testified about how, people just kind of throw that term around, not really knowing what they're talking about.
All right. It's 9 minutes to 3 o'clock. I think, number one, it's always good to take a bathroom break at this point in the afternoon. It's been almost more than an hour and a half since we resumed after lunch. So we'll take a bathroom break, and I think I and the commissioners will go down to our room and discuss this at least briefly. So when we come back, we can go from there. Obviously, we got two motions that we've heard and argued. But before we do that, are there any other motions, or is that it?
I think that was it, but just remember we sort of pivoted because we were dealing with the motion to schedule dates, and so we pivoted to this.
We got to come back to that. Right. Okay. But Mr. Norwood said that would in part depend upon the rulings on these different things, right? So yes, we'll come back to that after we've done that. So with that, 8 minutes to 3, we're gonna make this at least 20 minutes. Hopefully we'll be done by then, but we'll see. Yes, sir.
I suggest you vote to go into closed session.
Yeah, I was gonna.
Okay,
That's all that counts.
so, okay, thank you. Mr. Garvin,
All right, I'll make a motion, we go into closed session for 20 minutes.
I second.
Clerk will call the roll.
Chairperson Barney,
Yes,
Vice Chairperson Llewellyn,
Yes.
motion carries.
and to note that we're doing that to discuss matters with our attorney.
okay. All right, so with that, we will do that and stop recording now, come back in 20 minutes. All right, so I think the commissioner just made the announcement. I'm not sure if it was.
We're out of closed session.
Okay. And so with that, after discussion, here's what the commissioners have decided they want to do. First, because there was some reference by Mr. Norwood to Mr. Garvin, I know there was a motion that we dealt with Mr. Garvin as a city councilor. Early on, there was a motion to disqualify the city councilor, and his name was mentioned at that time. I can't remember precisely what was put into the record then. So we're going to ask Mr. Garvin, if you would, to step up to the mic to address the question of that Mr. Norwood raised of whether or not you have been involved in any way in this investigation. Mr. Garvin?
Do you want me to just
Say it.
say something?
Say what have you had any involvement in this investigation of the actions to terminate Director Gray?
I had no involvement in it. I was unaware that it was happening when it apparently was happening. I was never asked any questions about it, and I had absolutely no knowledge of it until Sheena Hamilton told me that there was going to be a hearing, that this was happening, and she wanted me to be available to the commission to provide legal advice if it was needed. I have not reported anything to Sheena Hamilton other than something like we're done for the day when I get back to the office. Nothing of substance. I don't discuss the matter with Sheena Hamilton or with Mr. Harris or with Mr. Norwood, except in my capacity as being counsel to the commission.
All right. I think that covers the issue with regard to Mr. Garvin.
Well, can I respond? First of all,
what your response is what?
My response is, first of all, I'd like to put him under oath, but
Well,
I'll take his word.
I'm not quite sure that you can.
Okay, that's fair
He's an
enough.
officer of the court.
As
This is
am I.
not the court,
But aside from that, it's not the issue of, in fact, he just supported our view of the world, which is this, that those cases that we cited in support of our motion to disqualify, you've got to purge it on the front end. And in this case, he just testified, or he just, as an officer of the court, advised this tribunal that the purging, purported purging, happened on the back end. After all of the damage is gone.
What purging are you talking about?
What these cases talk about is that
What cases talk about?
the cases that we cited in support of our motion to disqualify this office, that, and those cases involve disqualifying prosecutors' offices. But what you have to do on the front end is to put all of those safeguards in place on the front end so that it's not tainted, not after they've investigated and been fully advised and all that sort of stuff, and then bring him in off the sidelines at the back end. It's not his involvement that we're necessarily concerned about. It's the fact that the city councilor has been involved. And that's what disqualifies that office, right?
And you think that disqualifies the city councilor's office from
Completely.
appointing an attorney whose sole job is to give advice to the commission, the two commissioners here, the Civil Service Commission, and without having any involvement in the anything else related to the matter.
Yes, absolutely.
You think that disqualifies?
That's
All
what
right.
the case is saying.
All right, we already ruled on that motion
You
to
already
disqualify the city council's office. That was overruled and denied. This has just been something that may or may not have been on the record before, but now it is. So I don't think it changes anything. So with that, am I correct? Am I correct? Okay, so with that, the next thing we'll go to, all right, we have come up with a revised schedule, but we do have a question. Mr. Norwood, we plan to come back next Tuesday, February 4th. We talked about that when we were here, right?
Yes.
All right. And of course, we would be presenting your case.
Yes.
At that time. Mr. Harris mentioned, and we've got this motion that the two of you have submitted. I should say that Mr. Harris has submitted the motion to eliminate to prohibit any evidence about political interference. Both of you have argued it. Mr. Harris suggested perhaps briefing it. All right. If you wish to address the issue of whether or not evidence of political interference, political motivations for the termination should or should not be admissible, you need to have any brief submitted to the commission by Monday the 3rd, so that the commissioners will have the opportunity to review them before we come back on Tuesday the 4th.
Yes.
All right? Now, we've got your motion about political interference. We got also the motion to quash subpoenas, and they both really pretty much revolve around that same issue. Mr. Norwood, we've talked before. Now, you want to put on what is your offer of proof as to, you've argued that you were being denied putting on a defense.
Yes.
All right. What is your offer of proof as to what is it, what evidence is it that you're saying that you would present that we are denying you the opportunity to put on in your defense?
Well, as the tribunal knows, this is not your typical case. In my typical case, I don't come into a courtroom unless I've deposed witnesses and locked them down in their stories so I can present it. But we haven't had that opportunity because all of these witnesses are represented by Mr. Harris, apparently, and the rules that have been adopted, both before and after, say we can't depose witnesses. So
what rules are you talking about?
I'm talking about the newly adopted evidentiary processes and the prior processes which preclude us from doing the discovery that we need. We actually asked, as part of the submission, which was also denied off the record, which was the motion to allow investigatory subpoenas so we can get access to the documents and then perhaps take some depositions. But we never got access to the documents, and here we are. So from the standpoint of offers of proof, I would like to put on these witnesses and make offers of proof by examining them, and then we'll submit it along with the Court of Appeals or wherever we end up with this thing and let them decide if it was improperly excluded.
All right. Now, the commissioners have not denied any request for an investigative subpoena. I don't.
You have, because that was one of the motions that I teed up back in October.
When did the commission deny that?
Well, I wasn't in that secret meeting that you had on the 7th where we had 13 motions listed, which included that particular motion that was not ruled on, either denied or not. But be that as it may, we made the request in October, and the record should bear that out.
All right. So you're you don't, are you saying you do not have any offer of proof as such
Well, no.
here today?
Well, my proposal is that we have offers of proof by examining the witnesses. And if that is rejected, then I could work over the weekend while I'm out of town to put together written offers of proof and make that part of the record, if that's the position of the tribunal. Our preference would be to examine these witnesses, so essentially we're gonna be going on supposition, what we understand they should say if they tell the truth. If they lie, well, that's why we should have them on the stand.
Well, can you give us an idea now of what is
Well,
it-
I've given, okay.
what it is that you say these witnesses would say,
Okay.
or would you rather do it in writing?
Well, what I would like to do, if you haven't decided yet, if you already decided, it's a waste of time, but what I'd like to do is to go through the areas that I think they would respond to, and then, to the extent allowed, supplement it with a writing, so we can have a complete record of what we believe that evidence is gonna show as relates to political interference, as relates to the involvement, the intimate involvement of the city councilor's office in the investigation and in the political interference, as relates to the mayor and her true intentions, as relates to the thing which includes videos and various other things that we plan to introduce. With respect to the comptroller, as I've outlined, we've outlined that. The offer of proof is that she communicated to her that nobody's ever, in her 20-year tender, and he said, well, we got an affidavit. Well, we had traveled by affidavits. We get a chance to cross-examine her on her affidavit if that's what the
Both
position
of you
is.
address the comptroller, though.
The
The
comptroller,
question is offer of proof as to what the mayor would testify to. If you had the mayor as a witness, what are you
Okay.
saying you would expect the mayor to testify to that would be relevant to any issue in this case?
okay, what we will be able to testify to is that there is a pattern and a practice by our lovely mayor from day one to wrestle control of civil service away from a merit-based system to a system based on cronyism, to a system based upon her political appointees. The testimony is, and we've already got some of that in the record, is that essentially her dregs non-civil servants on her payroll for whatever reason, political reasons, crony reasons, patronage reasons, tried to offload and has offloaded in a number of instances those dregs onto the rolls of civil servants, giving them those civil service protections ahead of the civil servants who have worked decades to get in those positions. It's going to show that. It's going to show that she never reached out to her, not even for a cup of coffee. Her sorority sister that she hired, what she thought she hired and what she got didn't line up. What she thought she hired was a sorority sister who was going to bend to her will, not a strong-minded person who has fought vigilantly to protect merit-based systems, to protect civil servants. When she realized what she had, this is the result. This is political interference. The fact that she's even launched this ship shows political interference, right? It's also going to show Sheena Hamilton and Sarah Baker told her, Nancy Cross told her that you better watch your back because the mayor's view of the world is that the reason some of these positions aren't being filled is that you have a concerted effort to sabotage her political campaign, right? We got the Reverend who's been a thorn in the side of the mayor by way of his official duties as part of the Oversight Commission for the jail, constantly criticizing the lack of access, the lack of adequate medical treatment, the lack of adequate security, and various other issues that have been investigated, first by a committee and then by the oversight committee that came about as a result of that investigation. He's also, by the way, suing the city for the Stockley situation and injuries he suffered there. And the icing on the cake was the fact that, despite the fact that the Reverend supported the mayor the first go-round and also supported Cori Bush the first round, he decided to reach out and support Wesley Bell, who ultimately defeated Cori Bush, who was a good buddy, political buddy of the mayor. And the combination of those things, along with her testimony before the Charter Commission in January of 2024, whereby, despite the fact that she tried to coordinate the communication on this thing, she was blindsided by the mayor getting out there and said, I want to take control of civil service. And she was on this agenda to testify before that Charter Commission, and she did. And she exercised her views in favor of a merit-based system, in favor of anti-cronyism, in favor of anti-patronage. And when she gave that talk, from there, the Ice Queen arose. And we already heard testimony about how she publicly tried to humiliate her by going around and giving gifts out to everyone in the building, literally, figuratively rather, except her. Why? To shame her. Like she's trying to shame her now. Her chief of staff already said, you should resign, take the honorable route, fall on your sword, or else we're going to embarrass the hell out of you. We're going to get into your personal business. We're going to talk about your husband sneaking around. We're going to drag all of that in this public hearing. That's political interference. Threatening her with the email. Her lawyers walk into the building, happy-go-lucky, and she gets a note saying, your lawyers are in the courthouse. If that ain't evidence, then I guess it is time for me to retire. Because the practice I came in where they had due process, where they had rules, where they had fundamental fairness, this is not the practice I came into, and I suspect it's not the practice you came into, Your Honor. This is not it. Plain and simple. That's the case. Now, you all don't have to believe the case, but that's the case we're going to present. And you have every right to say, well, maybe I'll believe the mayor and not believe her. And that's what tribunals' factual findings are all about. But to deprive us of our opportunity to present those facts, well, what can we do? Particularly when the charter specifically says that you all have an obligation, not on the back end. His argument is, oh, get fired first, and then hire lawyers to go litigate it for a year, and then come back and do it all over again. You're responsible for dealing with this today. We're putting this out here today. There might not be a tomorrow. She's here today to protect her reputation. She's here today to protect her dignity. She's here today to protect her family. She's here today to protect this civil service system that was created by our ancestors to guard against the very type of political interference that this mayor is engaging in today. We got evidence of her attempting to interfere last week. So that's what this whole thing is about, as it relates to just the mayor. Sheena Hamilton, she's been running around, talking out there, visiting out. What role does the city council have going out to the airport, talking to the director out there, saying, what about this slot for Rick Frank? Can you make room for Rick Frank so we can clear that deck? That's what the evidence is going to show us to the airport commissioner and Sheena Hamilton. They haven't said that she didn't whisper to her and say, you better watch out, because they are suggesting that you're trying to interfere with my political career. That's in play. All of this is related. These are not isolated situations. And when you're trying to establish corruption, and I'll say it, this is corruption at the very top of this government. It ain't easy. And we ain't expecting it to be easy. But what we do expect is have the opportunity to present those witnesses under oath. He can say what he wants to say all day as an officer of the court because they've been duping him. We have every right to present a defense. He doesn't say we don't have a right to. Didn't your letter say you have a right to present a defense? You have a right to present witnesses. I didn't see the parenthetical was said only if you're going to call a mayor and only if you're going to call the city council and only if you're going to call the comptroller. That's not what the letter says. It promised her the right to present witnesses. And now, through you all, he's cutting the legs off of those very rights that were set forth in the notice, the same way he's cut off the legs of the notice that said we have the right to argue motions before the court, before the tribunal, and we couldn't. But somehow, every motion they filed the day before, we have to jump and come in and argue. That is not fair. You wouldn't want it. You wouldn't want it. You wouldn't want it. And I don't know anybody out, can we get a poll? Anybody want that kind of due process? That's the mayor. That's the comptroller. That's Sheena Hamilton.
All right. If, I'll leave it up to you. If you wish to supplement that, and there were some other witnesses whose names you did not mention, if there's anything that those other witnesses you're suggesting would have to present that's not included in everything that you've argued, you
Well, I
would
thought
need
that
to
was-
supplement that because
I just want to make sure we had the mayor, we had the comptroller.
you
we
said
had
you were not
Sheena.
going to, you said you were not going to call two of them.
Oh, you mean the two? Yeah, the two we weren't going to call. But I'm just trying to make sure we're on the same page in terms of the witnesses that you all are deciding whether or not they are allowed to testify. You've already ruled on the mayor. I don't know
Mayor,
if that's
the
under
comptroller.
reconsideration, right?
Mayor, the comptroller, Sheena Hamilton, who else?
The
he-
airport director.
And the airport.
And the
director.
airport director.
Right.
And the other two were Nancy Cross and Jason Fletcher.
Jason Fletcher.
And
who
you
we
said
will
you were not
call.
going to call either one of those two.
Yes, yes.
And the airport director, you've already made a record about what the airport director
Yes,
would testify
yes.
to. So, what you're saying is you do not have anything further in writing that you wish to supplement this
I would
with.
say that if the court, if the tribunal is inclined to deny it today, we would like the opportunity to submit a one-page supplementation on those witnesses.
All right, well, we're not going to rule today because we are letting you make your offer of proof, and then we're letting you brief this political interference issue and have that in if you wish to by Monday. So if you wish to supplement it with anything additional, you need to have that in by Monday as well so that we can review it.
Yes,
Commissioners can make a decision
yeah,
before we start on Tuesday,
yeah.
right? All right.
Can we
So-
establish a time on Monday?
Uh,
Since we're back here on Tuesday, I just want to have.
Monday is my oral argument, so we ruled out the afternoon, so we're talking Tuesday, and the submissions would be on Monday.
Yeah, I'm just trying to
No, let's
clarify
talk
the
about the-
time
what-
those submissions will be due on Monday so
What
that
time
we
the
have ample
submission will
time
be
for
due?
Tuesday.
Oh, that's not,
You're going to delegate this, I hope?
no, we're gonna collaborate. In
All right.
fact, I think we've already got it written, but
All right.
we'll
So,
say
12
2
o'clock.
12 o'clock Monday,
By noon Monday, have these briefs and submissions
supplemental,
by
Offers.
noon on Monday to the
Yes.
commission.
yes.
Okay.
And just so I understand, so is that gonna, so Monday is the deadline for, in addition to the briefing, but the offer of proof supplement? Is that-
Yes.
Okay.
Right? All right. Then, the only other thing we had
I'm
left
sorry,
was,
just one more, I need to clarify one more thing. So as to the, so you had ruled that the motion to quash the testimony of the mayor was sustained. Is that?
as of right now, that's where it stands. However, the purpose of an offer of proof is for us to consider what is being offered
Yeah.
and revisit where we're right or wrong in sustaining it.
Right, I just need to understand kind
Okay.
of where we are.
That's where we're at. And so then we are going to plan on meet on Tuesday, the 4th. Now, we also had talked about follow-up dates to that. And Mr. Norwood, the commissioners talked about, do you think you could promise us that, were you available on Monday, the 10th? Or not?
Yes, and the 11th.
Were you available, Mr. Harris, on Monday, the 10th?
And to put a ribbon on it, I think either way, the tribunal rules will be done by Tuesday, the 11th.
Well, that's
We're
what they
gonna
were.
give you an even bigger ribbon.
Okay, so you don't have, your students are very lucky that you can go see them on Friday.
Well, I mean, appreciate that. They will appreciate it.
All right,
Thank you.
Yeah.
so we'll meet on Tuesday, and then we'll come back the following Monday, the 10th, right?
Yes.
Correct.
And Tuesday, the 11th, if necessary, but you're gonna, in any case, have it wrapped up by then,
And we'll have our closing arguments at the end of that,
at that time.
the half hour.
Whenever we wrap, once you rest, Mr. Harris, you're gonna not be asking for any rebuttal, are you, or are you?
Who knows?
You don't know, okay.
I don't know if the commission's gonna rule on all these fantastic.
Well, of course, I understand there's some issues that are up in the air, that's why I'm not really expecting you to give me a definitive answer. I'm just, can hope. Right?
We can all hope.
I can
Keep
pray.
hope alive.
And the 11th will have a 10:30 start time.
10:30, all right? So with that, I think we're gonna wrap it up today, all right? So, we can, I believe, go off the record. We're done. Anybody have anything else that needs? I don't think so. I see anybody? All right, so we're off the record. We're done today.